mother has been indisposed since yesterday he had to leave for Kerala, my lord. Can you visit on 4th of September, my lord?
4th September.
Yes.
Item 26.
4 September.
On a request made on behalf by Mr. R.P. Sharma, Senior Counsel, matter stands referred to be listed after 4 weeks.
How long?
26.
26 years.
Yeah, please, Lordship. Lordship, I beg to mention for listing on tomorrow, my lord. It's
Why?
matters in this appointment of Gabura, my lord. In the appeal, also already we have appeal has been allowed in favor of the petitioner, my lord. They have filed a review petition, my lord, without hearing, my lord, the petition and the order has been passed, my lord. And they have
When was the order passed?
on 12th, my lord, 12/8, my lord. And we have received on 14th.
Right, subject to clearance of defects. Yes.
My lord,
Fresh motion.
Lordship, tomorrow, Lordship.
my lord, I beg to mention for listing of a matter, my lord, in admission column, last posted on 7/6/2024, my lord.
Tell me when do you want it?
My lord, next Tuesday, my lord.
Tuesday. All right. Tuesday.
My
Lordship,
lord, pleadings are completed, my lord.
Tuesday.
Yes.
Lordship, I beg to mention one item, that is pension matter, last posted on 21/02/2024. So may it come on, Lordship, 8 or 9 September, 9 September, Lordship. Pension matter, he is not getting the pension, regular pension.
For admission. Let
Right,
it come
yes,
on a miscellaneous day.
Yes, Lordship.
Let it come on a miscellaneous day. 8th of September.
Lordship.
May I please, your lordship. Lordship, with the consent of other side, your lordship, I beg to mention item number 29. 29, your lordship.
29.
That is club with item number 28 also. I have informed the council appearing in the item number
28 and 29.
Yes, my lord.
You're mentioning both.
No, I am mentioning for item number 29.
Who's for 28?
28. Yesterday I informed.
Lordship, otherwise he may take some time, Lordship, but the date may kindly be fixed.
Lordship, 2 weeks because I have to find a reply, my lord. And he's posted
Item 28, 29 on the request made by the council for the petitioner.
2 weeks
Item
time.
29. Matter stands referred to listed after 2 weeks.
Yes. Very obliged.
Kindly a date may be fixed because
5th of September.
I'm obliged, Lordship.
Yeah, Lordship. Lordship, I beg to mention for listing, Lordship, this pending since 28/1 January.
Next 26th. Sorry, sir. 29th.
Wait, Lordship.
Yes.
My lord. This is the admission matters, my lord, for listing. This is the termination of service, my lord.
27th.
27.
My lord, in item number 15, the lordship was inclined to take up the matter for disposal. The learned senior counsel who was appearing for the petitioners, he is in some personal difficulty. I have filed my vakalatma today. So may I be granted 1 week's time to prepare the matter, Your Lordship? There is some urgency on our part also.
All right. After 1 week.
1 week on a fixed day, Lordship, on 28th, Your Lordship, which is a Thursday, Your Lordship.
28th.
Deeply obliged.
Lordship, praying for listing or two similar matter, my lord. Matter pertains to suspension, my lord. Suspension.
Suspension, yes.
My lord.
For admission.
Admission, my lord, yes.
29.
May I plead, your lordship? Lordship, I beg to mention item number 20. I want to withdraw this matter, my lord.
20.
20.
Item 20 on a submission made by MS
L. Wajida, my lord.
L. Wahida. Matter stands dismissed on recall. Interim orders, if any, stands vacated. Yes.
Obliged.
Please, Lordship. Lordship, I beg to mention item number 19. Lordship, may kindly adjourn the matter for the day.
19.
Yes, Lordship.
Passed over. But 19 is mediation.
Yes, Lordship, but the learned.
You wait. You wait for the matter to be called up. Yes.
Lordship, I beg to mention listing of an arbitration matter under admission column.
Admission column. 22nd.
Obliged.
For orders, items 1, 2, 3.
May I please, your lordship. Lordship, the connected writ petitions, my lord. We have preferred read appeal and listed tomorrow, my lord. Before the
Tomorrow.
division bench, yes.
All right. They listed after 1 week.
Yes,
You
ma'am.
apprise the court.
My lord.
It is submitted by the counsel representing the respondents, Mr. S. Dotto,
My lord.
that that a writ appeal has been preferred
Yes.
against the judgment and order dated 25/2,
My lord.
2025.
That was a series, my lord. In the main leading case, we have preferred the appeal.
Several writ petitions came to be disposed of and directions were issued, and non-compliance of which directions, and for non-compliance of which directions, the present contempt petition has been filed. So it is submitted that the matter is listed tomorrow
As writ appeal number 256 of 2025.
as writ appeal number 256,
256, 2025.
2025. It is submitted that these matters therefore be deferred, enabling the parties to apprise the court on the orders that may be passed by the appellate court. List again after 2 weeks.
According to him, Lordship, he is not preparing appeal against me, Your Lordship.
My lord, connected series, my lord.
There is a lot of connected series. He has preparing appeal against one person, Lordship.
We
How
have filed
can-
2, my lord, already.
How can?
Now we have,
it in
others are also, my lord, we are ready to file, my lord.
Till date not filed.
All right.
Because
After
connected-
1 week, after 1 week.
Let me be.
After 1 week, list on 29th.
Obliged.
Please.
Item 4 also, Lordship, connected with item number 1 to 3.
4 also same, man.
All right. 1, 2, 3, 4.
Yes, sir.
Same orders.
Obliged.
For admittal, item 5.
Lordship, kindly pass over the matter.
Why?
N. Upadhyay is legs in other court also.
My lord, he sent a letter, my lord, through my WhatsApp, my lord, and my lord. The query which was asked by the AG, my lord, it was sent on 12 August, my lord. So this morning he sent it, this letter to me, my lord. So which was asked by the accountant general. So after it maybe come after 2 weeks, my lord, this pick on to finalize, my lord.
You shared that.
No, sir, I'm there.
Lordship,
you have already forwarded the first proposal, Lordship, meeting of the queries of the accountant general, Lordship. It was sent on 12/8. I have already forwarded a soft copy to him also.
Who has filed the petition? Husband.
No. The petitioner himself, herself, Lordship. The son is the nominee, Lord. Divorcee.
This information has been sent. That's it. To the accountant general's office. Let us see what comes up.
Yes, let's.
This is by
Chief engineer, Lord.
irrigation.
Lordship. Additional chief engineer. Issue to Abu. Forward.
In deference to the earlier orders passed, the council, standing council for irrigation, Mr.
N.
Upadhyay submits that in response to the queries raised by the accountant general's office, the information has been forwarded by communication dated 12/8, 2025. So, as per the information furnished, the following information is furnished, 1 and 2. Stop. The Para, the counsel for the Accountant General, Mr. S.K. Medi, submits that he would like to complete his instructions as to what steps the department has taken after the receipt of the instructions. Accordingly, matter stands deferred to be listed after 2 weeks,
3 weeks, my lord.
3 weeks. 3 weeks.
Lordship, on 11th of September.
11th,
11 September, my lord, day after, my lord.
not 11th, 15th,
15th, Lordship.
My lord,
17th
17th,
September,
17th.
17th. 17th September.
Yes, Lordship.
All right,
Obliged, Lordship.
all right.
Anything further to be heard?
You know, yes, I have to give my reply
Oh, I thought we had-
because,
this is that certificate.
yes, yes. I'll give a short reply, Milord. Now, Milord, Lordship has noticed the facts. Now, Advocate General was arguing, basically he was trying to project that as if it is a case of fraud. He was harping on it again and again and again. Now, my lord, I wonder, this is a litigation between the petitioner and the state or between the, my lord, person who has given a particular opinion. Or the Advocate General has given this opinion. Based on Advocate General's opinion, state is defending the action now. That's why I wonder whether it's a litigation between the petitioner and the Advocate General or petitioner and the state. Because basically it is the opinion of the Advocate General.
He's entitled to be.
No, I'm not saying that. And he's arguing also. Anyway, my lord, now I'll draw your lordship's attention to one. Now, my lord, one basic thing must be noticed in this case. This certificate was obtained in the year 2006. Now, alleged fraud is of 2019 and 2020. How is it even correlatable, my lord? My certificate was given by the competent authority in the year 2006. Now they are trying to correlate with certain, events which took place in 2019 and thereafter.
But these arguments,
Yes.
and these objections,
Yes.
you are entitled to take before the authority. Your primary
no,
ground for objection is that
No, my lord, question is, no, my lord, it's not a question of which authority, my lord.
the authority who's issued the show cause.
Why should they, how this so called notice is even maintainable?
So your primary argument is that once the division bench has held the judgment,
Exactly.
no further proceeding.
And it has attained finality and review was filed by the state, review was withdrawn. Withdrawn means we are compelled to withdraw. Because there was a lot of resistance from the court was not inclined to accept by the argument of the state. Therefore, no, my lord, one very important aspect is there. My lord, now initially they have filed an IA which is also on record. If your lordship would kindly take that IA, my lord.
IA.
Yes. Now, I'll place also judgment of the Supreme Court regarding the scope of reopening the matter. Now, if your lordship would kindly take the IA 170 of 2025.
Yes.
Now, my lord, this is very important in this case, and this order has also attained finally. Now, please come to page 24 of the IA, my lord. Now, by this order, a show cause notice which was issued during the pendency of the writ petition was put to challenge, and this honorable court, like coordinate bench of this honorable court, was pleased to stay. And while staying it, my lord, certain observations have been made which supports my plea that it's a litigation between the petitioner and the AG. Please see, my lord. Para 13. However, during the currency of the judgment and order dated 1/6/23, passed by the division bench in writ appeal number 42 of 23, a subsequent inquiry was held by the CID on 31/7/23 to look into illegality and validity of the earlier inquiry report dated 3/10/2019, which has already undergone scrutiny of this court. In fact, another inquiry of 26/12/23 was also conducted by authorities to look into the veracity of the applicant's caste certificate. The aforesaid inquiry dated 31/7/23, dated 26/12/23 being in direct conflict with the judgment and order dated 1/6/23 passed by the division bench of this honorable court, the applicant approached this court under Article 226 of the Constitution by filing a petition being WPC number 3125, and this court on 24/6/24 was pleased to issue notice. During pendency of the aforesaid writ petty proceeding, the authorities on 2/9/24 issued a show cause notice to the applicant, wherein the applicant has been intimated that SLSC in its meeting held on 25/7/24 has decided to initiate a de novo inquiry as regards the status of the caste certificate to this applicant. This is what was challenged in this IME, not situated thus the present interlocutory application in WPC has been filed seeking inter alia stay of the operation of the said order. Now, my lord will kindly skip this. Please come to, my lord, page 29.
It was filed by you.
Yes. Yes.
Page?
Page number 32.
32.
No, please come to page 29, my lord. Para 28.
Yes.
Apparent that this court upon perusal of the inquiry report dated 3/10/19, which found the allegation brought against the applicant as regards subject caste certificate is based on no truth, accepted the said inquiry report, and accordingly set aside the speaking order dated 26/2/21 issued by the SLSC against the applicant. It further appears that thereafter Anti-Corruption Liberation Union, that is the complainant before the authority, referred a writ appeal number 42/23 against the aforesaid speaking order dated 26/2/21, wherein division bench of this court by judgment and order dated 1/6/23, also after testing the report of the vigilance officer, inspector of CID on the touchstone of the principle laid down by the decision of the apex court in case of Kumari Madhuri Patel, reported in so and so held that inquiry report submitted by the inspector of police CID does not indicate even in the slightest that the particulars given by the applicant were false or social status certificate have been fraudulently obtained. My lord, these two paragraphs, paragraph 15 and 16 are from the division bench judgment, my lord, which in my humble submission is very important. Therefore, Lordship will kindly permit me to read this. Testing the report of the vigilance officer, that is inspector of CID on the touchstone of the principles laid down in the case of Kumari Madhuri Patel, we find that the inquiry report submitted by the inspector of CID does not indicate, even in the slightest, that the particulars given by the candidate were false or that social status certificate has been fraudulently obtained. Thus, in terms of the first part of para 13.7 of the guidelines formulated by Kumari Madhuri Patel, which provides that in case the report is in favor of the candidate and found to be genuine and true, no further action needs to be taken. No further action was called for in the present case after the detailed and reasoned inquiry report has been submitted by the inquiry officer. However, SLSC got another parallel inquiry conducted through Circle Officer, Jorat Revenue Circle, who apparently had no jurisdiction to carry out such inquiry, as indicated above. Another significant fact which needs to be noticed is that as the report of the inspector CID, which was submitted after conducting a thorough inquiry in terms of Kumari Madhuri Patel, did not give any indication that social status certificate was obtained by respondent, writ petitioner by providing any false or fraudulent information, rather concluded that the social status certificate was validly and lawfully obtained, the authorities had no option but to accept the report and affirm the social status certificate of the respondent writ petitioner as per the guidelines contained in para 13.7 of the judgment in Kumari Madhuri Patel. Hence, the contrary conclusion drawn by state level scrutiny committee is absolutely illegal and unwarranted. As a consequence of the above discussion, we are of the firm opinion that learned single judge was perfectly justified in accepting the writ petition filed by respondent number 1 herein and quashing the speaking order dated 26/2/21 passed by the state level scrutiny committee and affirming the social status of the respondent one herein as OBC courts. Thus, the impugned order does not suffer from any infirmity, and as a consequence, the writ appeal falls and the same is dismissed as being devoid of merit. Now, my lord, if now any inquiry is permitted, then they will be sitting over the judgment of the division bench of this honorable court. Because, my lord, as per the Kumari Madhuri Patel's mandate, it is the inspector of CID who alone is competent. The circle officer is not. And now the basis of the inquiry is circle officer's report. I'll come to that, my lord. Then, my lord, lordships will kindly come to page 32, para 33. Now, these two pages are very important. In fact, my lord, I'm sorry, I'll have to read page para 32 also and page 31. Paragraph 4, let me read from 31, I'm sorry, my lord. Therefore, it is manifestly apparent that both the learned single judge and division bench of this court has affirmed the findings of the inquiry report dated 3/10/19 of the Inspector of CID. It appears that despite the aforesaid orders of division bench of this court, the respondents have taken decision to initiate a de novo inquiry as regards the caste certificate of the applicant on the basis of a legal opinion which is projected in paragraph 4 of the affidavit filed by the respondents 1, 2, and 3 on 18/7/24. I was referring to this legal opinion below. Paragraph 4 of the said affidavit in opposition is reproduced herein for ready reference. Pursuant to the Honorable High Court's order dated 24/11/22, passed in WPC number so-and-so, and subsequent order dated 17/2/23 passed in WPC number so-and-so, the matter relating to service of the petitioner is under consideration of the higher authorities in the government. The authorities have explored legal remedies against the order dated 24/11/22 passed in WPC number 22/86/21 and obtained legal opinion as regards the service of the petitioner and follow-up action to be taken in view of the Honorable Court's order as mentioned above. In the legal opinion, displeasure has been expressed as regards the manner in which the caste certificate verification report dated so-and-so was submitted by the CID. So, my lord, after the division bench of the High Court has affirmed that report of the CID, the law officer of the state expresses displeasure, which was not taken note of very lightly by this Honorable Court. As so-and-so, submitted by the Inspector of CID and also pointed out various issues, and it was suggested that judgment passed in WPC and all subsequent orders requires to be challenged before the appellate forum. However, in view of writ appeal number 42 of 1923 filed by one Anti-Corruption Liberation Union against judgment dated 24/11/22 and dismissal of the aforesaid appeal by the judgment dated so-and-so, the department could not file appeal. The department was further advised to prefer SLP before the Honorable Supreme Court of India in that event. Competent authority on 14/6/23 has also directed Principal Secretary, Home and Political Personnel to examine as to whether there was a mala fide intent or misconduct on the part of the concerned SP CID and Inspector of CID in reference to the caste certificate report submitted by them. Accordingly, Personnel Department requested the Home and Political Department to make an inquiry into the matter in which the caste verification report was submitted by CID. In response to the same, Joint Secretary to the Government of Assam Home and Political Department by letter dated 14/11/23 furnished the letter dated 7/8/23 issued by IGP CID stating inter alia that there was no mala fide intent or conduct on the part of the SPCID in connection with the inquiry. However, inquiry reveals that Inspector Dibbojyoti Datta, the then inspector, has made perfunctory inquiry while verifying the caste certificate of the petitioner, and various vital aspects were not considered by the inquiry officer. The Joint Secretary of the Government of Assam, Home and Political, has also provided a copy of the inquiry report, which was conducted to ascertain as to whether there was any mala fide intent of conduct on the part of the earlier inquiry officer or not. Now, this was the affidavit of the state, my lord. Now, Lordship will see what is the view a coordinate bench of this Honorable Court has taken. Regarding the aforesaid paragraph, it appears that the very basis of issuing so-called notice dated 2/9/24 pertaining to the decision to initiate a de novo inquiry as regards the status of caste certificate issued to the applicant is due to legal opinion which expressed displeasure as regards the earlier inquiry report conducted by the Inspector of CI Police, CID. Pertinent that the said affidavit opposition is shown by one Rup Kamal Rabha, who is serving as Deputy Secretary to the Government of Assam, wherein he averred that pursuant to this court's order passed in WPC number so and subsequent order passed in so pertaining to consideration of the service of the petitioner, authorities have explored available legal remedies against the order dated 24/11/22 passed in WPC and obtained legal opinion as regards the service of the petitioner and follow-up action to be taken in view of the Honorable Court's order. It is further averred that legal opinion received displeasure has been expressed as regards the manner in which caste verification a report dated 21/10/19 was submitted by CID Assam on the basis of the inquiry report dated 3/10/19 submitted by the Inspector of Police CID, wherein it was also pointed out various issues and it was suggested that judgment passed in so and all subsequent orders requires to be challenged before the appellate forum. It appears that no appeal against the judgment and order of the division bench has been preferred by the state before the apex court. Pertinent that though the state authorities have filed a review petition being so against the judgment before the division bench, curiously the same was withdrawn by the state authorities. Apparent thus that respondent authorities based on aforesaid legal opinion decided to initiate de novo inquiry against the issue of the applicant's caste certificate and accordingly show cause notice has been issued. It defies the logic and conscience of this court as to how respondent's legal officer has expressed displeasure to the inquiry report dated 3/10/2019, which has been tested both by the single judge and division bench of this court and has been found to be valid. I'm reading it again, my lord. It defies logic and conscience of this court as to how the respondent's legal officer has expressed displeasure to the inquiry report dated so, which has been tested both by the single and division bench of this court to be found to be valid.
Displeasure is with regard to the language used in paragraph.
No,
4.
legal opinion. Displeasure to the inquiry report dated, which has been tested. No, my lord. This honorable court.
See, you have been in that office earlier. Yes. You are entitled to pass an opinion.
Saying that.
Whether that opinion, what action the state takes.
I'm on a slightly different point, my lord. What I'm on is, my lord, having given an opinion and again arguing the same matter that I'm on that, my lord. That means you're trying to stick to your views. That means, no, lord, this is a very, I'll place judgment of the Supreme Court on that. I've come up with those. So, my lord, it defies logic, conscience of this court as to how respondent's legal officer, now this direct aspersion, has expressed displeasure to the inquiry report, which has been tested both by. So, my lord, a coordinate bench of this honorable court has taken the view. An inquiry report which was tested by single judge and division bench, how can, in respect of the same very report, law officer of the state can express displeasure? This order has attained finality. There is no application filed to, my lord, expand these observations. This court strongly deprecates the tone and tenor of the language used in paragraph 4 of this so. It is expected respond to mindful of the languages used in this so. Then my lord will kindly come to para 37. It appears that respondent authorities, though filed a review against the judgment and order of the division bench, has later on withdrawn the same and has not preferred any appeal before the apex court. Therefore, the inquiry report dated 3/10/19, which was tested and upheld by the single bench and division bench of this court, has attained finality. So I am on this, my lord. Even by this order, though it is an interim order, my lord, this report dated 3/10/19, which is sought to be reopened again and again, this honorable court says it has attained finality because two forums, a single judge of this honorable court and a division bench of this honorable court has tested it and has given and said that it is valid.
No, but if the state on materials comes to a finding that certain aspects.
No, there's nothing. No, I'm coming to that, my lord.
Whether the inquiry report is correct, incorrect is on a different issue. But can it be said that Madhuri Patil has put an embargo
Yes.
on all fronts?
Yes,
that
I'll place judgment, my lord. No, my lord, there is no other front. Only front is the legal opinion. What is the front? Front is the displeasure. My lord, officers, what they will do when the highest law officer of the state gives an opinion, expresses
Opinions are
displeasure.
Opinions. It is the action of the authority which matters.
No, but the action.
You can't take a shield under an opinion to say that no, because an opinion was
No,
given, we are
because of
doing
the opinion only it has been done. Even affidavit says so.
opinion may have been given, but ultimately it
No.
is the action or inaction of the authority.
No, my lord. Let us, my lord, there is something called public policy. Why, my lord, do we have this principle called res judicata? Then everything should be reopened every fine morning on the drop of the hat. Why the principle of res judicata has been judicially evolved? Because an issue which has been decided, we must give an my lord, finality to it. Otherwise, tomorrow, my lord, on the drop of the hat, everything will be reopened. Why, my lord, power of review is circumscribed?
We are on that.
Yes.
We are
No,
not-
I'll address on that also.
we are only concerned with this fact that whether is there a complete embargo on reopening an issue?
No, my lord.
Whether the reopening was genuine or not, whether it was correct or incorrect is a different issue. On the materials.
Yes.
On the materials, in some cases, it may be correct, it may not be correct.
My lord, my submission is twofold. First submission is this report dated 3/10/19 having.
Because this inquiry conducted by the authority.
Yes.
Also has to be taken.
No, I'll come to that also, my lord.
Into the correct perspective
Yes,
as to what is the extent of inquiry conducted.
Yes. And I'll also show from those inquiry, my lord, that there is nothing. My lord, all these aspects were, in fact, the materials based on which now issues are sought to be reopened were subject matter of challenge in that writ appeal.
Which is why I think the first question I asked is
Yes.
file a review.
I'll come to that, my lord. As such, the conduct of the respondents to initiate de novo inquiry against the applicant pertaining to the issue of subject certificate appears to be in gross circumvention of the orders by both single judge and division bench of this court, and therefore the same is wholly contemptuous. And you see the strong words which has been. In fact, it is apparent that respondents have resorted to issuance of show cause notice only to circumvent the order of this court as stated above. The said act of respondent authorities are not bona fide and appears to be exercised in extraneous consideration. Well, Lord, it is not me. It is a part of the judicial order which I am reading. And let's see the extent to which a coordinate bench has gone. So they say this reopening is an attempt, not a bona fide, it's a mala fide attempt because of extraneous consideration. And this order has not been assailed till that date. My lord, now having said all this, my lord, let us see what are the materials.
Who has filed this IA?
I filed this. We filed this IA.
No. This order is a part of an IA.
Yes, IA in this present proceeding. Because on 2/9/2024, a show cause notice was issued, we challenged that.
No. This IA is filed with the state.
No, this is filed by the state, seeking vacation of the order.
Vacation of this.
My lord, let me articulate my points, my lord. This order I have read just to place before your lordships a view which has been taken by coordinate bench in respect of this matter. Now lordship is hearing the matter finally. Lordship is entitled to take a view in the matter, which I am not disputing. I'll only assist your lordships. Now the first point which I will argue is, my lord, number one, the allegation of fraud.
1 minute.
Yes.
This order which was passed in an IA.
IA.
Whereby, what was the final order here?
My lord, or IA 2955 of 24.
Was state.
Yes, the last, when the matter was pending, my lord, another show cause notice was issued, which we put to challenge.
Yes. And this order is not appealed.
No, this order has attained finality. My lord, in the writ petition, we have challenged 2 reports and 1 explanation. 2 reports of the police in respect of the same subject matter. And during the pendency, my lord, another show cause notice was issued on 2/9/2024, which was put to challenge in IA 2955 of 24, and which was, my lord, wherein this order dated 29/24 was passed. Now, my lord, as far as my contentions are concerned, my lord, I would like to put it in this form, my lord. Number 1, the allegation of fraud is only a subterfuge, my lord. There is absolutely no question of any fraud. The reason is very simple. The certificate was issued in the year 2006. If any fraud I would have resorted to before issuance of this certificate. After issuance of this certificate, there is no requirement on my part to resort to fraud. In 2018, 19 or 2021, there is no requirement on my part to resort to fraud, my lord. Number 2, both the judgments of this honorable court has attained finality, and therefore the report dated 3/10/2019 of the inspector of CID, which was the basis for passing of the order, cannot be reopened. Third, my lord, now the AG's contention is there are 2 reports. One by the inspector of CID and other by the circle officer Jorhat. Am I clear, my lord? Now, as far as this circle officer Jorhat's report is concerned, division bench has already dealt with it. Please come to the division bench order for a moment, my lord. The division bench order is at page 147 in the writ petition. Now, if your lordships would kindly come to page 159. Page 159. Page 159, my lord. Please come to the 3rd sentence. A perusal of the said speaking order would reveal that scrutiny committee, though referred to the report submitted by Superintendent of Police CID Assam, but thereafter no discussion whatsoever was made.
We are not with you. Which page?
Page 159, my lord. Internal page 13 of the judgment, division bench. Page 159.
Yes. Which paragraph?
3rd sentence. On top, my lord. 3rd line from the top.
Okay.
A perusal of the.
Yes.
A perusal of the said speaking order would reveal that the scrutiny committee, though referred to the report submitted by the Superintendent of Police CID, but thereafter no discussion whatsoever has been made to the findings of the inspector's report in the speaking order. On the contrary, while coming to the conclusion that the respondent writ petitioner was not entitled to the benefit of OBC certificate, the scrutiny committee relied upon a parallel report which was got conducted through Circle Officer Jorhat Revenue Circle. Apparently, in terms of the judgment in Kumari Madhuri Patel, the Circle Officer has no jurisdiction to carry out such an inquiry. So, my lord, the AG's contention that apart from the report of the inspector, there is a report of the Circle Officer, that is why they want to go ahead, is not permissible. That has already stands negated.
Yes.
That is why a coordinate bench says, my lord, this is everything is being done because of extraneous consideration.
Yes.
So, my lord, Advocate General, my lord, in my humble submission, failed to take note of the report of the CID has been affirmed by the DB while rejecting the report of the CO. So, the Advocate General's contention is there is a requirement of a further inquiry because apart from the report of the Inspector of CID dated 3/10/2019, there is a report of the Circle Officer. Now, that Circle Officer's report was held to be not tenable in context of a inquiry under my lord, Madhuri Patel's judgment. So, my lord, therefore it goes to the root of the matter. Then, my lord, therefore, my lord, where is the element of fraud? Now, regarding fraud, let us come to it, my lord. It will be very clear. My lord will kindly come to page number 185 of the petition. Maybe. Now, this is the report which is under challenge in this case, my lord. One of the report. Now, my lord, at 185, please come to the last two sentences. Detailed report in connection with the matter has been submitted on 17th of July. The following observations are made. In the OBC certificate issued to Srimati Monsoon Borkakoti by All Assam Backward Classes Association, dated 13/11/2006, and countersigned by the then Extra Assistant Commissioner, Additional Deputy Commissioner Jorhat, name has been mentioned as Monsoon Borkakoti. So this is number one. Diganta Borua village headman of Sekonidhara Gaon, Jorhat East Revenue Circle, under whose jurisdiction Srimati Monsoon Borkakoti currently resides, had provided a copy of the letter he received from Sri Surendranath Bora, the then village headman of Dionengia Goalgaon, informing that late Shiva Prasad Borkakoti, father of Santanu Borkakoti, along with his family, was residing in so-and-so Gaon, Moza Misamora, district Golaghat, before 1950, and they belong to Coast community. The Surendranath Bora, the then village headman of so-and-so Gaon, denied issuing any such letter, confirming that they belonging to Coast community, thereby contradicting the statement of Diganta Borua, village headman of Sekonidhara Gaon, Jorhat East. My lord, let us be very clear about one thing, my lord. My father belongs to general caste. I never claimed that my father is an OBC. That is not my case. Our case is relying on the judgment of the Supreme Court in Ramesh Bhai Dabhai, my lord, that I was born and brought up in my mother's environment. I have faced the difficulties which normally a caste people faces. Therefore, in consideration of that, it was given to me. Because my father was in government service, all throughout he was, my lord, traveling. That my mother is an OBC, there is no dispute. So it was never my case that my lord, these are all, my lord, materials which was given by that that anti-corruption. These materials were considered, my lord. I'll show. Now, what is the third one? Third one is very interesting. So, my lord, as far as the second one, it is Diganta Borua, that is the village headman of my mother's village, gave it. That Surendra Bora gave it, it is their own making. And they say that Surendra Bora said something. Subsequently, Surendra Bora said, please ignorance. Is it my headache? You are trying to rely upon materials which do not exist, and you are trying to put blame upon me. Then my lord will kindly come to the third one.
They belong to that Coast community.
Yes.
They means who?
Mother. Not father. Father is a general category. Borkakotis are always general, my lord. Please come to C. Srimati Monsoon Borkakoti had received the letter dated.
No, but if you read this,
yes,
B,
yes,
it refers to the father.
Yes, my lord.
Father,
my lord, this aspect now on which they want to reopen, this was gone into in the writ appeal. I'll show her. That's what I'm saying. No, my lord, they were trying to project that my father is also, father also wanted to project that he also OBC. No. I think I'll have to place the DB judgment once again, my lord, where this aspect was gone into.
Where is the finding of the DB that you were brought up by your mother?
Yes.
Mother's family?
Yes. Just give you 1 minute. No? Yes, my lord will kindly come to page 156. Itu no, you know.
156.
Kindly give me 1 second, Miller. Yes. Thus, the task of physical verification has been assigned to the vigilance officer, and in the present case, it is the police officer, police inspector CID Assam, who acted as the vigilance officer. The vigilance officer is required to undertake the physical verification by going to the place of residence or the original place from which the candidate hails or usually resides. Upon receipt of the report from the vigilance officer, if the conclusion arrived at is that the social status claimed by the candidate is not genuine or doubtful or falsely claimed, director would require to hold a bipartite hearing after issuing show cause notice to the candidate. Paragraph 13.7 of the Kumari Madhuri Patel clearly emphasizes that in case the report is in favor of the candidate and found to be genuine and true, no further action needs to be taken except where report of the particulars given are procured or found to be false or obtained in the later event, the same procedure as is envisaged in para 6 would be followed. In case of Ramesh Bhai, the Honorable Supreme Court examined the controversy as to what would be the social status of a person, one of whose parents belong to scheduled caste, scheduled tribe, and other comes from upper caste or does not come from scheduled caste or scheduled tribe. It was concluded by the Honorable Supreme Court in paragraph 54 and 55 that in such a situation, the determination of the caste of the offspring is essentially a question of fact to be decided on the basis of evidence adduced in each case. In an intercaste marriage or marriage between a tribal and a non-tribal, there may be a presumption that the child has the caste of the father. This presumption may be stronger in a case where intercaste marriage is between tribal and a non-tribal and husband belongs to forward caste. But by no means the presumption is conclusive or irrebuttable, and it is open to the child born out of the marriage to lead evidence to show that she was brought up by mother who belonged to scheduled caste or scheduled tribe. In the said case, Honorable Supreme Court reversed the decision of taking away social status certificate without adverting to any evidence and on the sole ground that he was son of a caste or father. Thus, as a matter of fact, the ratio of the judgment in Ramesh Bhai rather helps the case of the respondent number herein and in no manner comes to the aid of the so-and-so. Then Milord will kindly come to para 14 minutes. Yes. Please come to page 157, last sentence, Milord. In the present case, factual foundation arrived at by the state level scrutiny committee has been held by the learned single judge to be erroneous because the conclusion was drawn by the scrutiny committee without following the mandate in Kumari Madhuri Patel. The report of the vigilance officer was never considered by the scrutiny committee. Hence, order passed by the scrutiny committee cancelling the social status issued to respondent was rightly interfered with by the learned single judge. Para 14. In the wake of the discussion made herein above, and keeping in view categorical affidavit by the state government authorities before the learned single judge placing on record the report dated so-and-so, which was prepared after a thorough inquiry conducted by vigilance officer, that is Inspector of Police CID Assam in the present case, under the supervision of the Superintendent of Police CID Assam, concluding that allegation regarding falsity of the social status certificate of Monsoon Borkakoti was based on no truth and only course of action required to be taken as per ratio and judgment in so-and-so was to accept the said report of the vigilance officer. For the sake of repetition, it may be mentioned herein that state level scrutiny committee, while passing the impugn speaking order, did not objectively consider the report of the vigilance officer, that is so-and-so, which was a mandatory requirement as per guideline laid down by the Supreme Court in case of Kumari Madhuri Patel. A perusal of the speaking order would reveal that scrutiny committee, though referred to the report submitted by the superintendent, no, this is not important. I think, my lord, in the learned single judge's order, these facts are there. I'm sorry, my lord. Single judge order to court. Yes, my lord will kindly come to page 142, the report of the officer, my lord. Wherefrom it will appear that father is a my lord general caste. Page 142, it's a part of the learned single judge's order. As entrusted, I visited different given locations of the alleged person and found the findings which have been presented below. This is the report. In respect of Srimati Monsoon Borkakoti, I visited her paternal address and present address in Golaghat and Jorhat. In course of inquiry, it is found that father of the alleged, namely Shantanu Borthakur, born and brought up at Silpugri, Guwahati, followed original rights of a Kolita community, and got appointment in Somala. He is a general caste. The said doctor got married with a lady at Jorhat hailing from Coast OBC community and used to reside at matrimonial house wherein alleged Miss Monsoon Borkakoti got birth at her mother's house on 12/4/1990. And since then she started her education at Jorhat and accepted the customs of Coast community. During 2006, while she was a student of class 9, she applied for OBC certificate on the merit of her mother's custom. It is a fact that father of the alleged, though got appointment MBBS doctor, however, he was not moved for OBC certificate as he was not born at Coast community. It is pertinent to mention here that in respect of issuing OBC certificate, Honorable Supreme Court of India passed a verdict referred to as so-and-so, and in connection with the Honorable appeal, the Honorable Supreme Court of India passed judgment that child generally belongs to father's caste. However, the child can claim mother's caste also in the certain situation that if the child is born and brought up at the house of her mother, who is hailing from other community, then that of her father. It is a fact that judgment promulgated not directly related with OBC. However, situation incorporated carried the ingredient for which the alleged Monsoon Borkakoti is seemed to be entitled for obtaining OBC certificate. Moreover, using the agency, issuing agency clarified that certificate issued is genuine and issued from their office. Photocopy of the OBC certificate issued by the President, All Assam, other backward class association, Guwahati. A copy of this certificate issued by local Gambura, namely Diganto Borua, so-and-so, circle. A certificate issued by Torun Chandra Hazarika, Gambura of Betioni, Kakotigaon, Moza, District Golaghat, and a copy of the judgment of the so-and-so. As such, it is established that allegation brought against Srimati Monsoon Borkakoti is based on no truth. The complainant perused only the father's caste, but did not go through the legal finding of the Honorable Supreme Court. So, my lord, that organization called Anti-Liberation Front, who was the complainant, my lord. Actually, my lord, her estranged husband is behind all this thing. That is besides the point. Now they are separated, my lord. Now, through that organization, my lord, they filed a complaint. Then this complaint was entertained, based on which case was referred and state level committee cancelled my certificate. Then I preferred the writ petition, my lord, and in the writ petition, these are the findings. Now I never, my lord, therefore there's B. The B is irrelevant. I never, there is no question. My father is in deathbed, my lord. There is no question of he applying for, my lord, OBC certificate at the age of 70 years after retirement. He has retired from government service. So, my lord, these aspects were gone into. It's not that this, well, after a hot contest, these orders were passed. Then, my lord, I was referring to that notice. Then I'll show, my lord, these very aspects were subject matter in writ appeal. I'll place it just now. Then, my lord, I was placing that notice. 185. Now, please come to page 185A, my lord.
185.
Yes.
Yes.
Capital A, the page which was reading, my lord. Now that Diganto Borua's part is over, now come to C. First is, my name is Monsoon Borkakoti, but in the some document it was shown as Monsoon. Now, but I'll show, my lord. Then C. Monsoon Borkakoti had received a letter dated Jorhat 26th of March from Deputy Commissioner Jorhat asking her to bring original document for verification. Later, the aforesaid letter was found to be fake, for which R.A. Koroti, IAS the then Deputy Commissioner, had submitted a written complaint to officer in charge of the Jorhat PS against unknown person for faking her signature. Because they have gone to such an extent that Deputy Commissioner's signature was forged and a letter was sent to the petitioner in the name of Deputy Commissioner that you were required in connection with an inquiry. Subsequently, my lord, an advertisement was issued in the newspaper by the Deputy Commissioner that nothing of this sort has been done. So number one is why they want to reopen, because my name has been spelled as Monsoon. Number two, my father wanted to obtain a certificate, OBC certificate, and supposedly one milord, this Bora, the subsequent Bora, Surendranath Bora had issued a letter saying something, but subsequently he withdrew his letter. And what is the third point of reopening? The third point is that there was a letter issued on 26th of March 2019, whereby Deputy Commissioner has sought explanation from me, which eventually turned out that it is not it never emanated from the office of the Deputy Commissioner. Now, will your lordship permit them to reopen this issue on these three grounds? Now, kindly see our reply, my lord. (199). Now, my lord will kindly come to page number 199. My lord, this was our affidavit filed in the review petition. Why division bench did not entertain the review? Kindly see, my lord, page 199. My lord, it starts at page number 186. This was our affidavit in the review, and I'll have your lordship's kind attention to page 199. That coming to the case at hand, S, my lord, S, that coming to the case at hand, though pleadings of the review petition does not specifically disclose what are the subsequent findings which entails review of the judgment and order dated 1/6/23. However, from a perusal of the letter dated 31/7/23, this is the letter which I placed, of Additional Superintendent of Police CID Assam, annexed as Annexure 6 to the instant review petition, it is discernible that 3 points have been mentioned as having not been incorporated in the earlier report dated so-and-so, which now forms the basis for filing review against the judgment and order dated so-and-so. Kindly see, my lord, the ground for filing review was this very letter. The first point states that the name of opposite party number 1 has been misspelled as Monsoon Borkakoti in a certificate dated so-and-so instead of Monsoon Borkakoti. In this regard, opposite party number 1 humbly states that such defect is a curable in nature and it does not in any way reflect about opposite party's non-entitlement for availing the same. Further, the said fact was all along before the authorities and the Honorable Court, because the caste certificate dated 13/11/16 has been part of the pleadings record of the case as well as SLSC. Therefore, it cannot be held to be a subsequent discovery as to allow the authorities to go for review of the judgment dated so-and-so. This second point speaks about a letter without any specifications like date, particulars, etc., purportedly issued by one Sri Surendranath Bora, the erstwhile village headman of Dionigna, Gwalgaon district, Golaghat, certifying that late Shiva Prasad Borkakoti, father of Santanu Borkakoti, along with his family was residing in the said village before 1950 and they belong to Coast community. However, Surendranath Bora denied issuing any such letter. Beloved, first of all, who brought this letter to fore? Is it us? It was that anti-corruption. and now what they say? However, as CID personnel states that there is contradiction in the statement of Diganta Borua, village headman, and so-and-so where the opposite party has been residing since her childhood. Now, without disclosing the statement of Diganta Borua, a contradiction is sought to be made out. Well, all that Diganta Borua said was that yes, her mother belongs to my village She was born and brought up in her village along with her mother. That is why she got the benefit of the judgment of the Supreme Court in Ramesh Bhai Dam Bhai. Now, my lord, this Surendranath Bora, whose case is it? Is it our case that we are relying upon that Surendranath Bora's certificate for my vouching for my father's OBC status? I have all throughout said my father is general. So, my lord, this aspect was subject matter of review. It is no longer res integra, whoever comes. Anyway, this is. Then, my lord will kindly come to the next page, my lord. Line about 1, 2, 3, 4, 5, 6, 7, 8, 9th line. But it was never the claim of the opposite party number 1 that her father belongs to OBC. Rather, it has been the persistent stand of the opposite party number 1 that her father belongs to general category and her mother belongs to OBC. Further, non-disclosure about particulars of the said letter gives reasons to believe that it is one of the documents which was brought on record by the appellant, Anti-Corruption Liberation Union in Writ Appeal number 42 of 23 as Annexure E. Colley. In fact, this document was, my lord, annexure in the writ appeal filed by against the judgment of the single judge. Hence, particulars of the same are sought to be concealed from this honorable court because some such documents were considered and rejected in the absence of any satisfactory answer from the appellant regarding its veracity. Further, such consideration clearly contradicts the claim of the review petitioner that such fact was subsequently discovered since they were party to the writ appeal. Therefore, on this count alone, instant review application is liable to be rejected. The third point mentions about letter dated 26/3/19 purportedly issued by Deputy Commissioner Jorhat asking opposite party number 1 to bring the original documents for verification. The said letter was subsequently found to be fake, for which R.A. Koroti IS, the Deputy Commissioner Jorhat, had lodged a complaint dated so-and-so before the officer in charge of the Jorhat police station against unknown person for faking his signature and seal. Accordingly, a case has been registered at Jorhat's PSK number so-and-so. Interestingly, CID personnel, for reasons other than bona fide, fails to mention in this regard. A press release was subsequently issued whereby it has been clarified that the Deputy Commissioner Jorhat has neither issued any letter to the opposite party nor has lodged any FIR against her. Such press release had to be issued in view of certain news being circulated that said Deputy Commissioner had lodged FIR against opposite party number 1. Needless to say that the press release was published in Joini's Donongbhumi newspaper in its daily edition dated so-and-so, as well as other newspaper. If some person having vested interest can fake this seal and signature of Deputy Commissioner just to harm opposite party number 1, then such person can go to any extent and fake other document also like the letter of the village headman. Nevertheless, the said fact also does not have any bearing in determining the social status of the opposite party number 1, and as such it cannot be a ground for review of the impingement. Now, my lord, not only the single judge and division bench, even the review, because of all these reasons, my lord, review was withdrawn. Now, if your lordship permits them to go ahead, then, my lord, it will be, they will be open a floodgate, my lord. There will be no end to it. These very aspects, my lord, these are the 3 basic grounds, and these were taken note of. Then, my lord will kindly come to the other report. Now, they want to improve it. Second report is at page 211. Now it's
No, the first report was by an inspector, CID.
yes,
Then
and Miller under this
also
under
a circle officer.
yes, Miller under this scheme of the, because Miller there is no law. This
There
is
a scheme. So
that
please-
is considered to be a self-contained court. They are the authorities inspector of CID, para 13 of Madhuri Patel. Now, my lord, lordship has seen, it was never my case that my father is an OBC. Now they are trying to build up a case. That is why it's a fraud. And my lord, my father is 70+-year-old. Why he will apply for an OBC certificate? He's a general caste person. And I never claimed that my father is OBC. All throughout in the writ petition, everywhere. And my lord, the review was filed precisely on these three grounds. And these three grounds are the only grounds now. There is no other ground. Why? Because circle officer's report says so. And circle officer has been rejected. This honorable court says if nothing doing. Then my lord will kindly come to page 213. Now please come to page 213, para 13. This is the second report which is under challenge. During the inquiry, a letter was submitted by Anti-Corruption Liberation Union, that is the writ appellant Miller. The letter was addressed to the circle officer, Dergaon Circle, from the then village headman, Sri Surendranath Bora. The letter stated that Santanu Borkakoti rented a house in same village for 3-4 years, and the landlord belonged to Coast community. It may be assumed that on the basis of being a tenant in Dergaon, and also for the strength of OBC certificate, his daughter Monsoon Borkakoti Santanu Borkakoti applied for OBC certificate. There's nothing below. I never claimed that. In another document relating to furnishing RTI reply, additional document Jorhat addressed to the Anti-Corruption Liberation Union was submitted. It is stated that Santanu Borkakoti did not have any ancestral property in so-and-so village. During the inquiry, a fake OBC certificate issued in the name of Santanu Borkakoti bearing dated so-and-so. So kindly see me, Lord. Why in 1919 Santanu Borkakoti will, my Lord, apply for an OBC certificate? And my Lord, these documents were before in the writ appeal. It does not bear any signature, nothing. Anti-corruption. However, when we requested for, my Lord, normally people take years, my Lord, to register an FIR. And when there is an office phone call from the upstairs, my Lord, then they can do everything. Otherwise, people are at loss to register an FIR. It is assumed that the original copy must be, it is assumed, kindly see, my Lord, it is assumed that original copy must be in the possession of the beneficiary. It is assumed. First of all, you ascertain whether this document really exists. If it exists in office. So where is the question of drawing a presumption that it will be in my father's possession? And anti-corruption.
So where is that counterfoil or something?
Yes.
Not available.
Not available. Not available. Restrain on the, that's why I said, my Lord, if the writ appeal records are called for, my Lord, all these are a part of the writ appeal. Annexer E-Colli in the writ appeal.
What does it contain?
This certificate, these documents. Writ appeal 42 of 23. If a lordship calls for that, annexer E-Colli, these are the documents which are considered and rejected. Moreover, a formal communication white memo dated was issued to Srimati Monsoon Borkakoti, but till that there is no response in respect of the said so and so. Anyway, Lord, end of the day, their allegations are very simple. First, my name was wrongly typed out. Secondly, Surendranath Bora issued some certificate that my father belongs to OBC. Subsequently, he retracted. And thirdly, my Lord, the Deputy Commissioner has issued a notice to me asking for some clarifications, but it's so transpired that the Deputy Commissioner never issued that letter. Now, my Lord, what are the materials before you on which the Advocate General was so much satisfied that he had to express displeasure? That displeasure was not taken not very lightly by this Honorable Court. This was taken not very seriously by this Honorable Court with a scathing remark, and that stands in the record. So therefore, my Lord, is it not an abuse of the process of authority by the people who are yielding power and authority? Why your lordships will permit this? Lordship will certainly not permit this. Rather, I'll pray, my Lord, this writ petition should be allowed by awarding exemplary cost to the state. It is nobody's business, my Lord. This is not how government is run.
Where is that division bench view?
Yes, my Lord. Regarding?
The materials which were before the court?
Yes.
On the basis
Paragraph 15, 159.
Page number?
159.
159.
Testing the report of the vigilance officer that is Inspector CID on the touchstone of the principles laid down in case of Kumari Madhuri Patel, we find that the inquiry report submitted by Inspector CID does not indicate even in the slightest that the particulars given by the candidate were false or that the social status certificate has been fraudulently obtained. Thus, in terms of the first part of the paragraph 13.7 of the guidelines formulated in Kumari Madhuri Patel, which provides that in case the report is in favor of the candidate and found to be genuine and true, no further action need to be taken. No further action was called for in the present case after the detailed and reasoned inquiry report had been submitted by the inquiry officer. However, the SLSC got another parallel inquiry conducted through the circle officer Jorhat Revenue Circle, who apparently had no jurisdiction to carry out such inquiry as indicated above. Another significant fact which needs to be noticed is that the report of the Inspector of CID, which was submitted after conducting a thorough inquiry in terms of Kumari Madhuri Patel, did not give any indication that the social status certificate was obtained by respondent by providing any false or fraudulent information. Rather concluded that the social status certificate was validly and lawfully obtained. The authorities had no option but to accept the report and affirm the social status certificate of the respondent writ petitioner as per the guidelines contained in the paragraph so and so. Hence, the contrary conclusion drawn by the state level scrutiny committee is absolutely illegal and unwarranted. My lord, I'll place one judgment, my lord, on this point. Please have this. My lord, kindly have this J Chitra. This is 2021 9 SCC 8.
It's here. It's
Yes.
here.
To 2021 9 SCC 811, my lord. My lord will kindly come to para 8 at page 13 of the judgment. In the instant case, an inquiry was conducted by district level vigilance. Sorry, my lord.
Yes, yes. Yes.
In the instant case, an inquiry was conducted by the district level vigilance committee, which has upheld the community certificate in favor of the appellant. The decision of the district level vigilance committee in the year 99 has not been challenged in any forum. The recognition of the community certificate.
You are reading para 8.
8, my lord.
Oh, okay, okay. From the
In the instant case, an inquiry was conducted, sentence starting with. Oh, paragraph may not tell you, my lord. In the instant case, an inquiry was conducted by district level vigilance.
Yes.
Yes. In the instant case, an inquiry was conducted by the district level vigilance committee, which has upheld the community certificate in favor of the appellant. The decision of the district level vigilance committee in the year 99 has not been challenged in any forum. The recognition of the community certificate issued in favor of appellant by District Vigilance Commission having become final, the state level scrutiny committee did not have jurisdiction to reopen the matter and remand for fresh consideration by district level vigilance committee. The guidelines issued dated so and so do not permit state level scrutiny committee to reopen the cases which have become final. And this is important. The purpose of verification of cases, caste certificates by scrutiny committee is to avoid false and bogus claim. Repeated inquiries for verification of caste certificate would be detrimental to the members of the scheduled caste and scheduled tribes. And reopening of inquiry into caste certificate can only be in cases which are vitiated by fraud or when they are issued without any proper authority. Now, what is that fraud which the Advocate General would like to argue? 3 points. Monsoon, Surendra Bora, Deputy Commissioner's letter. And all were considered by in the review petition, and my lord, they withdrew the review. There is limit, my lord. Then my lord will kindly come to the other judgment. This is 2024 SCC Online SC 494. 2024 SCC Online SC 494. My lord will kindly come to paragraph 15.
Para
15.
15.
Sentence starting with now when the scrutiny committee, which is principally tasked. Now, basically on the High Court's scope under 226, my lord. Now, when the scrutiny committee, which is principally tasked with the fact-finding exercise for validation of class claim, had applied its mind and reached a conclusion, then in such a situation, whether a roving inquiry by the High Court was required. It is well settled that High Court as well as Supreme Court should refrain themselves from deeper probe into factual issues like an appellate body, unless the inferences made by the concerned authority suffer from perversity on the face of it, or are impermissible in the eyes of law. In the instant case, the order passed by the scrutiny committee reflects due appreciation of evidence, application of mind, and in the absence of allegation of bias, malice, or lack of jurisdiction, disturbing the finding of the scrutiny committee cannot be sustained. Now, my lord, in this case, the finding
was the order passed by the scrutiny committee here?
Yes. One second, madam.
Which was assailed.
Yes. Maybe. 96, my lord. First, if your lordships would kindly have a look at the caste certificate at page 36, my lord. Kindly see, my lord, the date. 13/11/06. Now, fraud is of 2019 onwards. Yes, had it been a case where my father also projected himself to be an OBC, in which case, my lord, their cooked up story is good, is worth considering. This was, my lord, a certificate obtained when I was in class 9. My mother never knew that I'll appear for ACS and get it, my lord. Yes, page 96.
Yes. What was the ultimate finding?
Yes. Now, my lord will kindly come to page number 99.
So the finding is at para A, 101.
Yes. My lord, if a lordship would kindly come to paragraph 99 because here also I said, my lord, that I was born and brought up in Jorhat. For para 4, my lord, at page 99. The committee examined the claim that Somali Borkoti belonging to OBC on the ground that she was born and brought up in the paternal home of her mother, who belongs to Coast community and largely accustomed with the culture of the community. In her written statement, has admitted that she was born and brought up in Jorhat Town Club area, which is an urban locality under so and so. So it is my specific case, my lord. What question? Yes. Then my lord will kindly come to page number 100. Srimati Monsoon Borkakoti has passed HSLC in the year 2007 and obtained her OBC certificate in the year 2006 on the criteria of adopting custom and tradition of her mother. So, my lord, these are for the, I'm just trying to show that her father was a general. Yes, please come to 101, my lord. In case of para 7, in case of Monsoon Borkakoti, as stated by her, her mother has been living in her parental home after marriage with Santanu Borkakoti, as their marriage was an inter-caste marriage. Parents of Santanu Borkakoti did not accept her as their daughter-in-law and never stayed with their father. However, during inquiry, it has been found that she and mother were never abandoned by her father. Her father has been working in the Health and Family Welfare Department and posted mostly in so-and-so Jorhat. Her mother is also government employee, irrigation, hence she continued to stay in Jorhat because of her so-and-so. Under the facts stated above, after proper introspection, observe the essay of the view that Monsoon Borkakoti, daughter of, and she so-and-so, has obtained certificate through unfair means. That's all.
No, the conclusion was that it was by unfair means.
Unfair means.
And what was the finding of the single bench?
Single bench finding was, my lord.
Page number?
Oh, if your lordship, before going to single bench, my lord, page 98, my lord, report. Kindly see, my lord. Para 3 on top. The committee has also heard Monsoon Borkakoti in its hearing held on so-and-so. She has also submitted a written statement wherein she mentioned that her father, Santanu Borkakoti, belongs to general category. So it was never my case that my father is an OBC. So, my lord, that's that Bora of village issuing that certificate. These are all cooked up. Yes, single judge's order, my lord, will kindly come to page number. Now, before lordship appreciates the single judge's order.
No, we just want to find out what is the, what was the order?
Yes.
What was the conclusion of the single judge?
Yes. I'll place it.
In view of this, because the finding is that it is by unfair means.
Yes, 137.
137.
Government produced the record.
So it was set aside.
Yes. Now, my lord will kindly see page 141. Single judge's order. At this stage, D. Mozumdar, learned additional advocate general, has produced the records before this court, which contains the inquiry report submitted by Superintendent of Police CID with regard to OBC certificate of the petitioner. The inquiry report is dated so-and-so, made by Inspector of Police CID. The said inquiry report is also reproduced herein. In inviting a reference, I have been directed to conduct an inquiry on contents incorporated in the complaint letter received from Directorate of Welfare of Plain Tribes and Backward Classes, enclosing 3 different complaints. One submitted by complainant Sri Biman Hazarika, President so-and-so, to Ranjit Kumar, additional so-and-so, and 3 Superintendent of Police, CM Vigilance, Guwahati, so-and-so. As entrusted, I visited different given locations of the alleged person and found the findings which have been presented below. In respect of Monsoon Borkakoti, I visited her parental address and present address, that is Golaghat and Jorhat. In course of inquiry, it is found that the father of the alleged, namely Santanu Borkakoti, born and brought up at Silpukri, Guwahati, followed the original rights, that is Kolita community, and got appointment as a medical officer, was posted at Jorhat. The said doctor got married with lady at Jorhat, hailing from Koch community, and used to reside at matrimonial house, wherein the alleged Miss Monsoon got birth at her mother's house on 12/4/1990. And since then, she started her education at Jorhat and accepted the customs of the Koch community. During 2006, while she was in student of class 9, she applied for OBC caste certificate on the merit of her mother's custom. It is a fact that father of the alleged though got appointment as MBBS doctor, however, he was not moved for OBC certificate as he was not born as community. So inquiry report clearly reveals that mother is OBC, father is not OBC. It is pertinent to mention here that in respect of issuing OBC certificate, Honorable Subna, he refers to that Ramesh Bhai's case, Milord. Then please come to the subpara. The photocopy of the OBC certificate issued by President All Assam Backward Association, Guwahati, copy of certificate issued by local Gambura, namely Digantopur of Sakoni Dhora Gaon, town so and local Gambura certificate issued by Torun Chandra Hazarika of Gulaghat, and a copy of the judgment of the Supreme Court. As such, it is established that allegation brought against the Monsoon Boro Kakoti, resident of Club Road, Jorhat, is based on no truth. The complainant perused only the father's caste but did not go through the legal findings of the Honorable Supreme Court of India. So that, my lord, by virtue of my mother's caste that I became an ST, this aspect was, my lord, not noticed. Then eventually, my lord, at page 145, a perusal of the inquiry report dated 3/10/19 clearly indicates that the allegation brought against the petitioner is based on no truth, and accordingly, closure of the inquiry was recommended. Perusal of the records produced by learned Additional Advocate General also indicates that the respondent has proceeded in terms of the procedure laid down by the Supreme Court in Kumari Madhuri Patel, and the final report was submitted on so and so. Accordingly, considering the inquiry report, the impugned speaking order issued by the state level committee against the petitioner is set aside and quashed. So this order against which writ appeal was preferred by my lord anti-corruption, then that writ appeal was dismissed. Then my lord a review.
State did not prefer an appeal.
State preferred a review in respect of the DB judgment.
After DB,
After DB.
there was no appeal.
There was no appeal to the Supreme Court. Then my lord, in the review petition, no. In writ appeal, my lord, the state participated in the proceeding.
No, but not, they did
Oh,
not.
they have not filed. They have not. And my lord, in the review petition, which when I think the review petition was heard for not less than at least 10 days, if I'm not mistaken. Records will be at least 10 days, my lord. Eventually, my lord, when we filed that affidavit at page 199, which I read, that the basis of review was 3 grounds, as is spelled out in that letter. When those were, my lord, demolished, then state withdrew the review petition. And my lord, the word used in the review petition is dismissed. Initially. Thereafter, on request, my lord, it was disposed of.
Once you withdraw, it is always dismissed on withdrawal. Or
In fact, my lord, I think CPC explanation says if a point is urged and court does not passes an order, then I think it's res judicata. I think CPC can get it. CPC. Section 11 explanation. CPC has a Yes. Explanation Roman 5, my lord. Section 11, explanation Roman 5. Any relief claimed in the plain which is not expressly granted by decree shall for the purpose of this section be deemed to have been refused. Section 11, explanation 5. So, my lord, this in my humble submission, my lord. And my lord, let me place that judgment in Madhuri Patil once, my lord. Why the learned single judge had taken that view, my lord? Or the division bench. Madhuri Patil judgment to do
It's here.
Yes, Lordship will kindly have that 1994 6 SCC, page number 241. Please come to para 13, my lord. $13.7.
One.
Please come to page 255.
Yes.
$255, my lord, para 13.5.
Yes.
Each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate into social status claim. So, my lord, the inquiry will be done by the inspector of CID, not by superintendent police, not by circle officer, or not by the, my lord, orders of AG or, my lord, CM. It will be, the inquiry will be only by the inspector, and that will be supervised by the superintendent of police, as was done. Now kindly come to 6. The director concerned on receipt of report from the vigilance officer, if he found the claim for social status to be not genuine or doubtful, or spurious or falsely or wrongly claimed, director concerned should issue show cause notice. Then my lord kindly come to 7. This is important in our case. In case the report is in favor of the candidate and found to be genuine and true, no further action needs to be taken, except where the report of the particulars given are procured or found to be false or fraudulently obtained. In the later event, same procedure as is envisaged in para 6 to be followed. So, my lord, in this case, since, my lord, the report of the vigilance officer was in favor of the petitioner, therefore the learned single judge was of the view the state level scrutiny committee had no business to go further. Their duty is to, because they were not the inquiring authority, they will act on the report of the inquiry officer. So therefore this single judge said, you have exceeded your jurisdiction, we are setting aside. Affirmed by the division bench. Review file, review dismissal. So this is the scheme, my lord. It's a self-contained code. Now, my lord, my father criminal case has been, my lord, started. They're harassing like anything. So, my lord, we are facing a lot of trouble, my lord. And, my lord, there was an order for reinstatement. I think we had to wait for months. Eventually, contempt petition had to be filed. Then, my lord, I was reinstated in service. Secretary was given personal appearance. Contempt proceeding was drawn up. Against appeal was filed by the state. So, my lord, to sum up my argument, my lord, my reply argument, now my certificate is of 2006. If there was any requirement of resorting to fraudulent practice, I would have done before 2006. After having obtained this certificate in 2006, I have no business to, my lord, tinker with that in 2019 onwards. Secondly, my lord, the 3 grounds which were sought to be pressed into service by the state for reopening the case has been rejected by this honorable court. Thirdly, my lord, the order in the IA, where the coordinate bench of this honorable court has already recorded that this action of the state is not only bona fide, it is actuated by extraneous consideration. Very strict words as well. Those orders have attained finality. Nobody has done anything. And finally, my lord, what is the scope? Can somebody's legal opinion override the judgment of the court, my lord? My lord, opinion is a matter between the client and the lawyer. Supposing, my lord, there is an order against me passed by an authority. I seek a legal opinion. Legal opinion says, no, this is wrong, how it can be done. Therefore, I'll come a writ petition, file a writ petition saying, my legal advisor has said so and so, therefore enforce my right. This is how, my lord, a legal system operates?
But
No, I'm just giving an example.
they are entitled to give an opinion.
I'm not saying, that's why I said, my lord,
But
opinion is a matter between the client and the lawyer. Court has got no business.
Whether the opinion is correct or wrong will be decided by the court. On an
Exactly.
appropriate
No,
proceeding.
that's what I'm saying, my lord.
But you
Therefore,
but can you-
is it
can you
not
find
a
fault?
case?
Can you
Is it
find
not a
fault?
case where the opinion of the law officer is sought to be foisted upon this petitioner, my lord? Anyway, my lord, Lordship will take a call on that.
But
Lordship will take a call on that.
we'll ensure that these are things which will not be
Yes. Anyway, my lord,
impressed upon.
therefore, my humble submission is, my lord, this girl has faced a lot of atrocities, my lord. Now time has come. She should be cleared from everything. That's my humble submission. Otherwise, my lord, this expression public policy will lose all its relevance. Because when we say an order has attained finality, it has got some, in legal connotation, it has got some meaning. If this is how, my lord, because somebody, my lord, I have not shown another order where while drawing up contempt, scathing remarks were made against CM also. In this case, very case. I'm not even drawing your lordship's attention.
You should.
Yes, I'll show. CM order. Yes. Because the second inquiry report was based on CM's view. Yes. Arun Dev Chaudhary, page 170. Page 170, my lord. My lord will kindly see, because in terms of the order of this honorable court, I was not reinstated, then I filed this contempt petition. Please come to page 173.
Yes.
Para 8. Thereafter, the matter was placed before different authorities, and finally an opinion from Learned Advocate General was sought for, and the Learned Advocate General on 19/5/23 advised to file a writ appeal against the judgment passed in WBC 2286 of 21. It is also seen from the affidavit in opposition that Learned Advocate General further opined that a fresh inquiry regarding verification of caste certificate of the petitioner should also be initiated. Thereafter, the Honorable Chief Minister opined that history will not forgive if the petitioner is reinstated in service without final verification of her OBC certificate, and accordingly advised to seek 15 days more time to take decision either on implementation of the court's order or to file a review petition in the High Court. So both these options they have explored. A statement has been made in the review petition has already been filed against judgment and order dated so and so passed in review. Thus, the option of review suggested by the Chief Minister has been opted. This court is of the considered view that history will not forgive authorities for reinstating the petitioner in service, cannot be a legal and valid ground not to implement an order of the Constitutional Court. Beyond that, law is well settled that court exercising contempt jurisdiction is primarily concerned with the question of contumacious conduct of the party who is alleged to have been committed default in complying with the direction in the judgment or order. It is equally settled that when there is no ambiguity or infirmities in the order, it is for the concerned party to approach the higher court, if according to him, same is not legally tenable, and such question has necessarily to be agitated before higher court, inasmuch as court exercises contempt jurisdiction, cannot take upon itself the power to decide the original proceedings in a matter not dealt with by the court, passing judgment or the order. In the case in hand from the pleadings and argument advanced by DNAT, it is clear that basic case of the respondent is that order dated 24/11/22, whereby the order of recommendation of the state level committee was set aside, was based on an inquiry report having no sanctity of law. The fact remains that even after having such an opinion, the state has not preferred any appeal till date against the order dated 24/11/22. Rather, appeal preferred by another respondent WPC was dismissed by the Honorable High Court in writ appeal number so and so. The fact further remains that judgment and order dated past in so and so, this is the where, my lord, there is an order for reinstatement, has remained unassailed till date. No review has also been filed seeking review of the order alleged to have been not complied. Though it is stated the review is filed seeking review against the judgment dated so and so, passed in the order of WPC is not a subject matter either of review, petition, or appeal. That being the position, this court cannot traverse beyond the order dated 17/23 past instancy for non-compliance of which is alleged. Now, para 17, having aforesaid satisfaction, contempt is drawn against respondent for willfully and deliberately violating order dated so and so. So, my lord, even in respect of chief minister also.
No, that is a passing reference in the order.
Yes.
There is no finding by the court. There is no contempt proceedings against the chief.
No, my lord, what I'm saying is, my lord, they were not complying with the order.
See, opinions granted
No, my lord, what I'm
by
saying.
constitutional authorities.
Yes. Is for the client.
For the client to decide, but
that
assuming-
opinion, my lord,
assuming
that,
an opinion is granted,
yes,
will not be a shield to not comply any
Yes,
court's order.
yes,
Then this is
correct.
exactly what was held.
correct.
Correctly held.
What I am trying to submit is, my lord.
But the court
And-
will not comment on how opinions are to
No,
be.
no, certainly not. Certainly not.
So it
That is
doesn't
the
concern us
prerogative of the
So
client.
therefore, it doesn't really concern what opinion was
No, no,
rendered.
my lord. No, but one of the a coordinate bench of this honorable court has taken note of that. Yes. No, my lord, what I am trying to say is, my lord, a communication between a client and the lawyer is a privileged communication within the meaning of evidence. It is for them how they, deal with it.
Therefore, it is not
But
even
when
proper
it-
for us
when it-
to
when it
necessarily
comes
look
to-
into the
Now, my lord, lordship has seen in the affidavit, the stand of the respondent is they have done it because there is an opinion. That's what I'm saying.
We are concerned with the arguments which you have raised
Yes.
based on Madhuri Patil.
Yes.
That once an inquiry is done, interfered with, upheld by the division bench, there is
End of the
scope
matter.
for the secondary provision, and this is nothing but an harassment.
Harassment.
And once it has been interfered with, and the ground of reopening is
And my lord,
fraud,
lordship
forgery,
kindly.
which according to you has also been looked into. by the-
Yes, the three grounds on which now they seek to reopen was agitated in review petition. We dealt with it, review was
And
withdrawn.
review was withdrawn, no appeal filed.
Therefore, in terms of, my lord, section 11 explanation 5, that relief was refused. So once it is refused, now they cannot reopen.
So may not apply.
And my lord, if your lordship calls for the record of the other writ appeal, Avexar E. Colli are those documents. Once my learned friend made a prayer, lordship said, all right, at the time of final hearing, we'll take a call.
For calling for the records.
Yes. Those documents are there, my lord.
We'll call for the records. if
Yes.
you- These are not enclosed to the present proceedings.
No, my lord. No, present proceedings have referred to those.
If you are praying for calling for the records. we
No,
can call.
all that I'm saying is, my lord, while considering the matter, lordship can call for the record and have a look at election.
Why should I call unless you want to rely on it? Unless you want to press on these documents before the score.
No, but our idea is only to bring to your lordship's notice that these are the documents which were very much part of their pleadings, and these are all gone into by the honorable and by the appellant in the writ appeal.
All right.
That's my humble
You
submission.
can give us a very short.
Yeah, I'll give it.
synopsis.
Day after tomorrow.
Whatever. Yes.
Lordship, we would like to give a reply, Lordship. The learned
Reply of
Like
reply.
the reply.
Lordship, a short reply, Lordship.
Then I'll also reserve my right of reply.
Lordship, day after tomorrow, Lordship.
Not day after. Day after tomorrow. There are several other partner matters. We'll fix a date. Take it in September.
Yes.
11th.
Mila.
11 September.
Yes. Deeply.
Further hearing. 11 September, Mr. K.N. Chaudhary, Senior Counsel, assisted by Mr. J. Patwari, has argued on behalf of the petitioner, and MS Arborwa,
Yes, Lordship.
appearing for the respondent state, submits that the learned AG would also like to address the court on certain aspects, and therefore is agreed to by the parties. Matter stands listed on 11th of September for further hearing.
Deployed.
We had rendered a judgment delivered, I think, 1 or 2 days earlier. You can just go through the judgment, and then I am bound by my judgment. So therefore, in that matter, we allowed the writ petition, remitting the matter back to the authorities to redecide on the aspect of the requirement of
108.
no, requirement of dismissing or releasing the petitioner by virtue of 108. So we had given our views
Yes,
on
but
that.
in our facts may be different in that case and our case also, because in
Principle
Yes.
that 4 heading entries, there is a decision, and then he was discharged.
in our case, Lordship, recent the last additional affidavit that Lordship directed us to file, that will show that in this case 108 has been followed.
You go through the
Yes.
judgment and you point it out to us. Counsel for the parties will address the court on this issue in view of a recent judgment delivered by the bench, by this court, rendered in so and so versus so and so.
It's
Whether
already,
this matter can be disposed of in terms of the state judgment.
it was already, Lordship had dictated that judgment.
Yes, yes. It's delivered. They will give you a copy. You can just go through it. You can take it and look into the judgment and tell us whether it is in
Applicable.
similar lines or it has to be distinguished, etc., whatever you want to argue. No, no, very quick. It will be, we'll have it in September. The 9th of September. 9th September.
I think 8 and 9.
Malada, may it please your lordship, Malada, and the cost of repetition and with your lordship's permission, our whole case was that, my lord, the statute provides that establishment, and my lord, the respondent.
There is no establishment branch.
And he never worked, and he worked in the accounts. To an RTI, we have brought it a document which shows that he works in the accounts section. And my lord, the minutes which were forwarded based on a CB submitted by them by an individual saying that on the basis of affidavit. On the basis of document submitted in their affidavit, they have stated in page 103.
See, first thing is there is a procedure that you must work in this department for whatever time. In the facts and circumstances, that department itself is not there, but particular section is there.
Marat, it is personal section. There are two branches. One is accounts, one is establishment. And the RTA says that he has worked in the personal accounts, never in the establishment.
No, so therefore, can it be said that the mandate of the rule cannot be strictly followed in the absence of that branch itself?
Malat,
Number one.
Malat, I understand your.
It has to be understood that notwithstanding there not being a section, there is a branch, and he never worked in that branch.
Malat.
Which is your argument?
Malat, at page 107, Malat, I disturb your lordship to this personal branch. The branch consists of following sections. Page 107, it is their affidavit.
Yes. Establishment matters.
My lords, personal section, establishment, and number 2, that is accounts sections.
He never worked in personal.
Personal, my lord, the RTI says in our read petition, last page.
Page number?
Page number 30. Personal is the main head note, and there are 2 sections. Serial number 4, page 30 in read petition, personal account section. And the service rule provides it should be established. Our case is, it is malice in law because on a non-existing department, the minutes has been taken into consideration. It's not German.
And what about you? You have worked everywhere.
But I have worked, I am establishment, it's there. In our minutes, you also will find it is there affidavit I am placing, my lord. The minutes are there. In our read petition also the minutes are there, my lord. Page 24. Page 24. Our read petition.
Lordship, just for the clarification, Lordship, what is the establishment, what is personnel?
Let him complete. We'll come to you. We'll come to you. Take your seat. Let him complete.
I want to assist the court with I have prepared a note on.
No. We'll look into it.
Page 24, your lordship will find the minutes. The petitioner, where it has been written, experience of relevant branch. Page 24, personal establishment. Page 24. The last column, experience of relevant branch as biodata submitted with the application forwarded by the district commission. Personal establishment. And my lord, as readers, respondent number 4.
That is also their accounts and establishment.
Accounts and establishment. So, my lord, and through RTI, and this has been obtained on the basis of the CV submitted by the respondent number 4. The CV is in their affidavit, my lord, page number 10. Well, it should be 102 or 103. 103, madam. It is the additional deputy commissioner writes it to whom it may concern.
103
of their affidavit. Additional deputy commissioner writes it to whom it may concern. I have also worked in all the departments that I have also stated in my paragraph.
This is a part of what?
It's a part of their affidavit, which was placed before the minutes by the selection committee. And on this basis, they have said personal accounts and establishment.
And what about ACRs?
ACRs
are better.
But my submission before lordship is that he is not eligible for the post. He is not entitled to be considered for the post. If he is not allowed to consider, because my lord, if seniority, ACS, everything will come subject to eligibility. And your last occasion, my lord, your lordship's query was that if the minutes was on the basis of the CB submitted by the respondent number 4, let them produce some better documents than the
Wait, what are your rules?
rules of, my lord, Assam Ministerial District Establishment Service Rules, 1967.
And the rule, the which the
Eight one,
parameters?
8 Roman 1.
Roman 1 and Roman 3, my lord.
Let me finish. One is the eligibility criteria, then the subsequent will come. 3 cannot bypass 1 and come thereafter. The last line says, and in the establishment branch in particular.
Yes.
That is my case before your lordship, and let them produce some better documents through than the RTI. With the RTI says, in my writ petition, my lord, page 30. And that was a document which they have produced. That was an individual opinion by an additional deputy commissioner to whom it may concern. At page 30, this is through an RTI, as serial number 4, personal account section for this, and nowhere they have stated that he is worked in any establishment. Now they cannot justify themselves that this is this and that is that. They have to show some better documents.
Where is the RTI page?
Page 30 in my writ petition, serial number 4. Is respective respondent number 4.
Yes.
Lordship, I'm appearing for the department, my lord, regarding the selection board, my lord. First of all, my lord, regarding 681 and 683 are the most relevant, my lord. 681 of the 67 rules, my lord. Okay, lordship has it. Lordship will see that post of AO shall be filled up by selection from amongst persons who have 15 years in any deputy
That we
commission.
have seen. We are
That
not
is correct, my
asking you
lord.
that. We are asking you whether he has worked in the
Yes, my lord. He has got work experience in the establishment branch because of the fact that, my lord, kindly come to the affidavit in opposition filed by the respondent number 4 at page 107 first, my lord. I'll show each and everything, my lord. 107, my lord. That is a notification, my lord. That is a notification dated 15th May 2018. Lordship will come to the relevant portion, that is 107. Here, my lord, at 107, has the lordship got it? Lordship, here it is given personal branch. Now, personal branch, the branch consists of the following sections.
We have understood that,
Yes.
Mr. Fukan. Why are you repeating this?
Because,
The
my lord,
question,
my
we'll
lord,
explain it for you.
my lord,
There is no establishment department.
there is no establishment department.
There is a personal branch which consists of 2 branches.
My lord.
One is establishment, one is accounts.
Accounts.
In fact, one is personnel and one is accounts.
Accounts.
Under personnel, you have establishment.
Yes. Seven matters.
Are we with you?
Yes, madam.
All right. Now you have to show us, in view of the RTI reply which has been received from your department, that there is no experience shown to the petitioner in the establishment work. Is there any other document to counter that?
Yes.
What is this?
This is the latest. Last time your lordship had asked me that I have got the records also, and I have the CV which Senior has been referring to. The CV is always supplied by the candidates. That means in this
Are you
case.
saying that whatever comes before you, you'll accept
No,
it
no,
without
no,
verification?
no, Your Lordship. They will see data from here. So all the data is in the record, my lord. Your Lordship has to see the record as well as, my lord, the other part will be.
You
addressed
show
by
us from the record and tell us what
We will show
documents are
the-
there.
Yes, Your Lordship.
What
But
is it? Which part of the query are you not understood?
No, I've understood the query, my lord.
Then
I
why
have
aren't
to
you
show.
giving us the
My
reply?
lord, the one report has been given there. A report has
We
been
don't
given
want
there.
your report.
The report has said that.
We want to see from your records.
Fine, I will show it.
The report, there is already an affidavit on record
Yes, please.
explaining all that. Why are you giving us a report?
The assessment reports will say, ma'am. Okay, sir. Okay, sir. Another product. It's a little voluminous, my lord, but first I will show the, my lord, report number 4. I will show the.
This report that you are presenting, where is the council?
Yes, go there.
One aspect, my lord, how was this considered, whether these things were considered by the minors, but before the selection committee? These things were before the selection committee or on the basis of the CV? Last occasion, the submission was on the basis of the CV.
My lord, the CV also is a part of the record, my lord. The CV is there. The applications of both the candidates are there. And my lord, the experience, it has been given there, is in the SCRs as well as in the book sheet, my lord, wherever they have worked. So each candidate has signed that, my lord. They have countersigned it saying that it is certified to be true. So that cannot be denied, my lord.
There is no establishment here for works relating to accounts and establishment. Is this a part of your affidavit?
My lord?
This document issued by the additional deputy commissioner?
It is
That
my lord,
certificate?
in the affidavit which we have filed, we have just annexed the minutes, my lord. We have not annexed the main this thing, but we have relied on the minutes because the minutes, the selection board, the grading is done of the 5 years is by the DC establishment, and then the other things, my lord, is done by the selection board. Based on
We
that,
don't want, we are not interested to know how you run your department. We are not. There's a specific query before the court that there is an RTI received from your department, purportedly signed by an additional deputy commissioner.
his department, not mine. That was RTA will be his, my lord. District establishment.
This is the problem. You see, you consider yourself to be a standing counsel, maybe for the purposes of your retention with the department, but you represent a part of the government before the court. So don't distinguish between his department, my department.
Right.
We are addressing to the government. Government has one voice.
Fine.
Should have one voice.
Should have.
So therefore, this document now shows that personnel department works relating to accounts and establishment.
And thereafter,
Whereas the RTI, which is enclosed to the petition, also issued by deputy commissioner, additional deputy commissioner, which shows that it is only with regard to accounts.
But my lord will kindly see thereafter. There is the gradings are there right after that. Definitely. Just after my lord, the chart has been made. There are different periods. There are wherever he has worked. There are for both the candidates. It is there. So based on that, they are grading. They have made that chart for the better.
Where is the
perusal.
chart?
First, the chart is there. I've shown him at page 189. It starts. The different arms license, and she was in excise, the different branches they have worked. So all that is given them. From page 189. after the thing. So so like that, ACRs of 5 year of each year, like that, it's going. Your Lordship will see the experience they have there. So they see all this, my lord. Okay.
What do you say with regard to this particular RTI?
The RTI, my lord, regarding the RTI, my lord, it has been.
From where did you get the RTI? DC.
DC.
Yes.
From the DC.
Why have you given contradictory reports? Have you filed any affidavit?
Lots of files.
What do you say regarding the RTI?
Affidavit filed with
Do
respondent.
you have the entire bunch of pleadings available with you?
Lots of. Some of the.
Some of the records.
Lots of, they have sent the entire records, lots of, in the some of the records I have got. Lots of, they have sent one instruction, lots of, regarding records.
Please come to page number 30 of the writ petition. 30.
Lots of, I got it.
This is the reply under RTI.
Lots of.
It shows he worked for personal department.
Lots of.
This is signed by additional DC, Nalbari. Issued on 22/7.
Lots of. On 20.
Yes.
Lots of.
Then come to 103. You have 103?
Lots of.
This is another certificate issued by Additional Deputy Commissioner Nalbari.
Lots of. Your personal experience joining the 7/6/2003 to.
So here you have
9 lots of.
accounts and establishment.
Lots of.
How is it possible? For the same dates, see the dates, 17/6/2003 to 8/12/2009. Issued by the same office. One of them does not appear to be correct. Page 30 and 103.
Lots of. Got it, lots of.
Then?
The personal banks in year lots of 17/6/2003 to 8/12/2009 lots of. Here's the personal banks here, same lots of in 17/6/2003 to 8/12/2009 lots of. 6 years.
It is the same date.
Same date lots.
But the nature of work is different. In 30, there is no establishment. And in 103, it says works relating to accounts and establishment.
In the record lordship, I got the record lordship. Here is personal branch works relating to accounts and establishment lordship. Here is signed by Additional Deputy Commissioner Nalbari lordship. Like in the original record lordship.
We have just shown you.
Lordship.
You have to tell us which one of them are correct.
Lordship.
Or both are correct.
Lordship.
It is issued by the same office. How can one person, how can the same office issue two different certificates?
It is corrected by lordship. I think lots of some manipulation is there, lots of true idea. In our record, lots of it shows that
Manipulation cannot be in a RTI. Manipulation to an individual giving certificate. RTI will not manipulate, but the individual certificate.
So if there is manipulation, then we have to call this additional deputy commissioner to court with all records. And if we find, then we are directing inquiry and prosecution against it.
Lordship, let's some time will be given, lordship. We'll obtain the instruction whether it is correct.
What were you doing for all these days? Do we have to invite all councils to obtain instructions separately? Once we give time, you are expected to go through the pleadings and come back with your instructions. You have also filed an affidavit. What is your status here in the affidavit?
my lord, in the affidavit,
In affidavit,
page
lordship.
para 6, para 10.
Where is the deceased affidavit?
My lord, this is page 36. It is filed by
Filed by this lordship,
Uh,
filed by the District Development Commissioner Bojali lordship. But respond number 3.
that's for number 3, page 36, para 10.
Para 10, lordship.
As regards our
Our
RTI.
lordship.
Here also,
Here stated that lordship respondent 4 has working experience relating to accounts and establishment lordship.
not denied that there is no RTI.
Here lordship main criteria is lordship para 8, lordship sub para 3 lordship. The main ACRs lordship. ACRs are better than petitioner lordship.
Have you read 3?
Lordship.
All of you? Please read it again loudly.
The appointing authority shall adverse the vacancies by itself or many instruct by the deputy commissioner concerned to advertise the vacancies, inviting application from suitable persons eligible for appointing in the post of administrative officer, fulfilling the requirement of the post of clause or sub clause 1 above the appointing authority shall
Fulfilling the requirement of the post.
lordship. As per clause 1.
Where is 1?
Lordship, the post of administrative officer shall be filled up by selection of amongst the persons who have
So,
served as at least 15 years service, lordship.
then
Then lordship, deputy commissioner establishment and have working experience with different branches in general and the establishment branch in particular, lordship.
exactly.
Then
So your the fulfillment must be of clause 8(1). Only then 3 comes.
after lordship. In our affidavit, lordship, it is stated that they must be lordship. Also, they have required more experience than the petitioner lordship in our affidavit lordship, which shows that 6 years, 6 months lordship.
What is there any record in the department to show that the petitioner has worked in these departments? Is there any record? Is there any interdepartmental, intersection communication which will establish that the petitioner has worked?
No, I have submitted one.
Respondent number 4.
I have submitted one copy, lordship. That's not something.
This is the same thing which you have given, which is already there at page 103.
In Annexer B, lordship, petitioners' experience are there, lordship.
These, where have they got it from?
This from the lordship, DC Bozali, lordship.
Get that record and show us.
Yes.
You are, come to your Annexure B.
Lordship.
There are certain dates mentioned here.
Lordship.
Where have they got the dates? These dates must be available somewhere. The AC to give wonderful to see. You have no instructions.
Lordship.
Get it by 2 o'clock.
No, lordship.
Today. Find out.
Then lordship, tomorrow, lordship, we will obtain that. Tomorrow, lordship.
Tomorrow.
Day after tomorrow, day after tomorrow. Day after tomorrow, lordship, we'll got that.
We had given you time earlier. What were you doing?
Day after tomorrow, we'll got that.
Yes, Mr. Islam. What do you want to submit?
Lordship, what is establishment?
That we don't need to know. We don't want to know what is establishment, what is account, what is personnel. We are only understanding what the rule says.
Lordship.
You do not dispute that rule 8(1) has 2 parts, A and B.
Lordship.
You will probably not disagree that rule 8(3) says you first satisfy rule 8(1).
Yes, lordship.
Now you say you have satisfied. You have given in your ACRs documents that you work from such and such period. Where from the records are those dates available?
Let them protest.
You have submitted. You had worked in the office.
Lordship, I have submitted,
You,
in my
you
affidavit-
get your instructions from your client where these dates are available.
In page 103, I have given the experience certificate.
That's
But,
right.
but
Come, let us come to page 103. 103. This is your document?
Lordship,
This is your document? Certified by an additional deputy commissioner?
Lordship,
Come to the right-hand side, period of incumbency.
Lordship,
These dates, have you noted it from your memory?
no,
Where?
I worked and,
When was this submitted? 23.
Lordship,
23? So you remembered from 99 that from such and such date to such and such you had worked
Lordship,
from your memory.
no. Department,
Department. So that is what we want to know.
Lordship, correctly.
So you show us. You show us that you have worked here and you sail through.
If I am to produce all the record, then I have to submit additional affidavit.
See, you have relied on this document.
Lordship,
This document is not a document issued by a superior to a subordinate. This is apparently a document which you have requested for.
Lordship,
Because it says to whomever it may concern, certificate.
Lordship,
Now this certificate is issued by the additional deputy commissioner.
Lordship,
This deputy commissioner, we do not know whether he was additional deputy commissioner from 99. Perhaps not.
Lordship.
So from where does he find these dates?
I have my records, then I will have to file additionally.
Right.
After two.
Yes, Mr. Fukon and Chakraborty.
Lordship, in terms of, as far as the department is, we have the selection board, we have produced the main
No.
record will come from the
DC.
DC office, main record, because we have produced long back.
Show us this page 103. 103. Do you have page 103?
He's got it.
103? 103 shows certain dates, period of incumbency. These are obviously recorded from some official documents. Where are these? From where do you find serial number 4? We are concerned with serial number 4, not with the other dates. That's the point of dispute.
4 and 8, 4 and 8.
Hmm?
4 and 8 also.
4 and 8, all right. You get 4 and 8? Yes, Mr. Chaudhary? That will sort out all the issues. I've heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Mr. A. Fukan for GAT, Mr. A. Chakraborty for State Council representing respondents so and so, so and so. And Mr. Islam for respondent number 4. Although the learned counsel for the GAT has produced the selection records during the deliberations which took place before the court, it is seen that the grievance of the petitioner is that the private respondent is not qualified under Rule 8.1. Under Rule, is it Rule 8.1? 681. 681. Under Rule 6.8 Roman 1 of these so-and-so rules. As he had no experience of working in the establishment section / the branch. So the counsel for the private respondent, on the other hand, strongly disputes the contentions raised and has referred to a document available at page 103 of the affidavit filed by the state, which shows that the additional deputy commissioner Nolbari has issued a certificate which reflects the period of incumbency of the petitioner in the concerned section / branch, namely at serial number 4 and serial number 8. Stop. This certificate reflects that the petitioner has the required experience and eligibility as he has worked in the establishment section.
Yes, 1 and not 4, my lord.
Yes, stop. The counsel for the petitioner on the other end has referred to an RTI reply received from the department, which is enclosed at
Page 30.
Annexure 6, page 32, the writ petition, where received from the office of the Additional Deputy Commissioner Nalbari, dated 22/7/2024, which reflects that the respondent number 4 had worked only in the personnel within bracket account section for the period 17/6/2003 to 8/12/2009. Stop. As such, both the RTI reply and the certificate RTI reply relied upon by the petitioner and the certificate relied upon by the private respondent number 4 appears to have been issued by the same office, namely the office of Additional Deputy Commissioner Nalbari. Stop. Both the certificate and the RTI reply reflect the period of incumbency of the private respondent number 4. Stop. The private respondent number 4 is shown to have worked in the personal department for the period 17/6/2003 to 8/12/2009. Stop. However, in the RTI reply, he is shown to have worked in the said department under account section, department or branch, whereas in the certificate issued again by the Additional Deputy Commissioner Nalbari, he is shown to have worked under the personal branch within bracket works related to accounts and establishment. Stop. But under such circumstances, this court permits the Government Counsel, Mr. Chakraborty, to complete his instructions as to which of these two documents correctly reflect the work experience, experience of the respondent number 4, in order that he becomes eligible under Rule 6(8) within bracket Roman 1. Stop. Where Mr. Chakraborty, learned Government Counsel, submits that he will have to obtain his instructions in this regard. He prays for
2 weeks time.
2 weeks time. List this matter again after 2 weeks. The records, selection records placed before the court are returned back to the Standing Counsel, GAD, Mr. A. Fukan.
11 September.
It is submitted. It is made clear that these records be kept ready for perusal of the courts on the next day, perusal of the court on the next day, if the need so arises. List again on, as agreed to by all counsel for the parties. List again on
11th September.
11th September.
Deeply obliged.
We'll come back at 2.
My lord, item 34. I have just now come to learn that Mr. T.C. Chutia is in bereavement. Someone died in his family. So they have informed me. It was a partnered matter.
Oh. Is it so? Yes. Item 34 stands deferred to be listed after 3 weeks.
My lord,
As it has informed the court that Mr. T.C. Sutia, additional senior government advocate who had represented the respondents, is in bereavement.
Can it be after 2 weeks, my lord?
After?
2 weeks.
We don't know, you said he's in bereavement, so you have to give him some time.
I have been informed, my lord.
So normally 2 weeks, 20 days, you have to give him some time.
If a fixed date is given, my lord.
Fixed date. 16th September.
Deeply.
Item 10.
Just 1 minute. It should be given.
My lord, the Contempt council is in his way hearing another court.
Hmm.
The password for a penny.
Yes, Passover.
Lordship, time being lordship.
11 and 12.
May I please your lordship, my lord, for the time being, may I call Mr. Buddha, my lord, Buddha Gogoi. I think it can be closed today, my lord.
Lordship, kindly pass over for the kindly.
Passover. Right, Passover.
14.
Yes.
Your lordship, kindly matter may pass over for the time being.
We want all the matters to be passed over for time being.
Yes, sir, he is coming.
Huh?
Yes. Bless your lordship.
If you.
Mediation?
No, lordship. I don't know why it came here, lordship.
Oh. Why, what is the matter?
Lordship, matter is regarding lordship pension. Terminal gratuity, they say that I will not get the regular pension, but terminal gratuity I will get. They had issued some letters, but that money is not being released by the bank, lordship.
By the bank.
Lordship.
Who's for the bank?
So, lordship, we didn't know that bank should have been made a party. We made the AZA party, the financial party, lordship. Bank was not made a party, lordship. On the last occasion, they wrote to the treasury that PPO number is not there. PPO number is not given to these people, this kind of people who gets terminal gratuity, lordship. GPO number is given. GPO number is there. But the bank says we are not going to release because you only have the GPO number.
You have to make them a party.
Lordship, that I should do, lordship.
File an application.
Lordship.
Mr. M. Bhagavati, learned counsel for the petitioner, submits that you'd like to array. Which bank is it?
State Bank of India.
State Bank of India. Which branch?
Lordship, Centralized Pension Processing Center, North
State
Eastern.
Bank of India as a party respondent, as
Lordship.
the terminal benefits payable to the petitioner, although released by the respondent authorities, have not been released by the bank.
Lordship.
Have not permitted the petitioner to withdraw from the bank. Stocky submits, therefore the bank is a necessary party and he is required to be arrayed as a party respondent. Remade is not objected to by Mr. Upadhyay and Mr. Borua, appearing for Accountant General. Borua for irrigation. List again after 2 weeks.
He is for irrigation, Upadhyay is for irrigation, he is for.
By now we are familiar.
Lordship.
They are also familiar with.
I also need to file a reply to Borua's affidavit, Lordship.
Parties in the meantime will also, is also permitted to exchange the pleadings.
Much obliged.
Whoever এইটো খতম কৰি লওক। এটা খতম কৰক।
Item 70. Yes.
Yes,
Listed for mediation, referring for the mediation.
who is for the petitioner?
Respondent is from Delhi and Shillong only.
Who is from the petitioner? Who is for the petitioner? None represents the petitioner when the matter is called up. Mr. So-and-so appears for the respondent councils list next week. None appears for the petitioner. None had appeared for the petitioner when the matter was called up last on 6/8/2022. Only for the NG Justice, the matter stands deferred to be listed again next week.
I am for 2 and 3.
Mr. C. Borua for
That's one for 2 and 3.
respondents 2 and 3, Mr. J.K. Goswami for
1 and 4.
1 and 4.
1, 4 and 1 and 4. The P now for 5.
Yes, Mr. P. Naik for 5.
19.
My lordship. So actually, matters come up for the mediation column, so lordship, we have not had a latest consultation, lordship, some time may be allowed, lordship.
We refer it, you have your consultation.
No,
in
lordship,
the
actually,
meantime.
otherwise the matter pertains to recovery for wrong fixation of pay, so there are some issues, contentious issues, lordship, so
Recovery has been made.
no, lordship.
There is an interim order.
Yes, lordship, actually, recovery cannot be made, lordship, there are, we have made our contention, lordship. Apart from that, lordship, to the conducting council, Mr. M.A. Hussain is also out of station, so for today, lordship, kindly matter may be passed over, lordship.
Yes. Council for the petitioner is not present and an adjournment is sought for on his behalf by Mr.
NZ Chaudhary.
NZ Chaudhary. Mr. J.K. Goswami appears for the respondents. Matter therefore stands deferred to be listed next week.
Much obliged.
My lord, regarding the payment of retirement benefit, my lord. Some amount my lord already paid, but my lord, we could not know, my lord, under what my lord paid, what amount paid.
We
because
refer
my
it to mediation.
My lord, it can be correct.
Right, heard counsel for parties. Referred for mediation. On 8th of September.
8 September.
8 September.
22.
May it please your lordship, our name is not reflected in the cause list, so we were not aware.
Who are you?
For the petitioner, lordship.
What is your name?
M. Das on behalf of P. Mohanta, lordship.
Names not reflected, then how did you know?
Lordship, we were informed, Lordship.
By whom? If the names are not reflected, how did you know that the matter is listed today?
Lordship, we were informed by an advocate, Lordship.
Why, how will that advocate know where, in which matter you appear when your names are not there and you don't know?
Lordship, matter relates to disability pension, perhaps this may not go to the mediation, it has to be sorted out.
It is submitted by the council that Mr. P. Mohanto appears in the matter, but his name is not reflected in the cause list. And that apart, the issues raised in the petition pertains to grant of disability pension, which was denied to the petitioner under the rules, and therefore the present writ petition has been filed. Mr. R.K. Dev Chaudhary, learned DSGI, appears with the state. Submits that since the council is not there, the matter can be taken up on some other date. Please, next week.
May I please lordship? Matters pertaining to my lord, pensionary benefits of workers. Well, similar issues has been pending before the Honorable Supreme Court, my lord. That matter is fixed on 3rd of September, my lord.
Is submitted by the council to the petitioner. Yes, Mr. Nayok. It is submitted by the council to the petitioner that the question involved in the present proceedings is the payment of
My lord, pensionary benefits of
pensionary benefits to master roll,
workers. my lord.
work charge,
Subsequently,
employees of which department? PWD.
yes, my lord.
Stop. Similar questions raised by other similarly situated persons are presently pending disposal before the apex court.
My lord.
In SLP number,
My lord, civil appeal number, my lord, 4514
civil appeal number 4514
for 2025, my lord.
of 2025. And it is submitted that the matters are directed to be listed in the apex court on 3rd
My lord, 3rd of September, it is fixed, my lord.
3rd of September.
I have the order, my lord.
Mr. Nayok, Standing Council PWD does not object to the prayer made. Mr. Medi for? Who is respondent 3? Accountant General. Accountant General. That view of the matter be posted after 8 weeks.
I love it.
Councils are permitted to apprise the court about any such order that may be passed by the apex court.
I love it.
24.
May please your lordship. Lordship, we have not contact with the petitioner, lordship. He is a very old person, lordship, and he have not any mobile phone, lordship. Perhaps he have not any silent wife.
Huh?
We have not any contact with the petitioner, lordship. He is a very old person and he have not any mobile phone, lordship.
So, what do you want the court to do?
Sometime for send a letter to the petitioner.
We are referring it to mediation. You send your intimation to the client and registry will also inform. Right?
Yes, ma'am.
Refer from mediation to be listed on 19th September. We have given you sufficient time.
25.
May I please your lordship? Lordship, in this matter, we are ready for mediation. We are ready for
Ready?
mediation.
Right. Mediation, refer to mediation, list on 15th September.
And this is disputing matter, minor say, may not go for mediation.
Why? Why are you objecting?
Because he was at the relevant point of time, he was the.
Who has come to the court?
My lord,
If they are agreeable for mediation, you refuse to mediate. Mr. E.K. Dotto for the respondent.
Timing I can tell.
Yes, APDCL.
May please your lordships.
Yes.
My lord, this matter came up on 30 July, lordships. And lordships, now on that day, lordships, 2 points raised, lordships. One, lordships, I have approached before the honorable court lately, lordships. This petitioner got the retirement in 2014 and I approached before the honorable court in 2023, lordships. 10 years, lordships. That point it was raised, lordships. And second point, lordships, this regarding that I have annexed 2 orders, lordships. Question has come at that time, lordships, regarding prospective or retrospective,
Pleadings
lordships.
are complete. Affidavits exchanged.
Exchange, lordships, completed, lordships. Now, lordships, I have 2 order, lordship, judgment. That is,
You have to first distinguish with the judgments placed by the respondents. It's recorded in the order itself.
lordships.
You tell us that the judgments are not applicable.
These are not applicable, lordships.
No, not like that. You'll have to refer it to the judgment and the facts and tell us how these judgments are not applicable.
Lordships, in that respect, otherwise, lordships, I will file an affidavit, lordships.
What affidavit you want? You have to argue the matter.
This-
They have relied on, their contention is Rafiq Mashi is prospective.
Prospective,
And
lordships.
then there is a question of delay and laches.
Lordships. Now,
And they have
lordships,
relied on these 2 judgments.
lordship, this all judgments and orders are retrospective, lordships. This, I have the judgment, lordships.
Yes, it is perfectly late.
Yes.
Lordships, this judgment delivered on 27 to 25, lordships, connects Sinau and another versus the state of West Bengal, lordships. Lordships, in these lordships, that is page 3, lordships. Page 3, lordships, from middle, lordships. The law as laid down by this court in Priyanka Srivastava versus State of Uttar Pradesh, 2015 6 SCC 287 has been violated, as all such complaints should now be accompanied by an affidavit. According to Priyanka Srivastava, the learned single judge of the High Court was of the view that the direction of this court in the above case would only operate prospectively and will not have retrospective application, and will thus not be applicable to the complaint lost against the appellants in the year 2010-2011. The appellant number 1, all the same who argued in person before the High Court, emphasized before this court and would argue that all the judgments of this court are retrospective in nature, and therefore it cannot be said that it would not be retrospective, particularly when it has not been specifically stated in the judgment of Priyanka Srivastava Supra that it will operate prospectively. Now, the law of prospective and retrospective operation is absolutely clear, whereas a law made by the legislature is always prospective in nature, unless it has been specifically stated in the statute itself about its retrospective operation. The reverse is true for the law which is laid down by a constitutional court or law as it is interpreted by the court. The judgment of the court is always be retrospective in nature unless the judgment itself specifically states that the judgment will operate prospectively. The prospective operation of a judgment is normally done to avoid any unnecessary burden to persons or to avoid undue hardships to those who had bona fidely done something with the understanding of the law as it existed all the relevant point of time. Further, it is done not to unsettle something which has long been settled, cause that would cause injustice to
You
many.
come to para 5,
Lordship,
end of para 5.
end of para 5, Lordship.
Para 5, you read para 5.
Lordships. This court in the above case then also is also direction that a copy of the judgment be sent to all the chief justices of the high courts who will circulate the said copy to all the magistrates so that they remain more vigilant and diligent while exercising the power under section 156(3) CRPC. Lordship, all judgments are retrospective.
No,
Lordship.
you did not see what is stated in para 5. Para 5.
It is necessary to mark the words in the above quoted para 30 that a stage has come in this country and thus the above direction would only be prospective. This would signify that what the court intended was that from now onward, it would be necessary that an application would be accompanied by an affidavit.
So, court interpreted the Priyanka judgment to say that this particular judgment has made some observations. From these observations, it is clear that it has to be prospective. Now, in Rafiq Mashi, it had laid down certain criteria, grade 3, grade 4, excess payment. These criteria were not there earlier. So these will be applicable prospectively. You fall into that category only from the date of the judgment. You are a grade 4 employee.
Grade 3, Lord.
Grade 3 employee. So you are relying on Rafiq Mashi for that observation of grade 3 and grade 4. That observation was not there earlier.
But Lordship, page 4, Lordships, now the law of prospective and retrospective operation is absolutely clear.
So not from page 4, there are other judgments on this.
Lordships.
This judgment is only an authority that whether this particular judgment referred here, Priyanka, whether it would be considered to be prospective or retrospective. Court held that it is prospective in view of the observations made in Priyanka.
But in page, Lordships, subsequently this clarification is given, Lordships.
Where?
So now the law of prospective and retrospective operation is absolutely clear. Whereas a law made by the legislature
You are
is
reading from
page 4, Lordship, top.
page 4.
Top.
Yes.
Now the law of prospective and retrospective operation is absolutely clear. Where a law made by the legislature is always prospective in nature, unless it has been specifically stated in the statute itself about its retrospective operation. The reverse is true for the law which is laid down by a constitutional court or law as it is interpreted by the court. The judgment of the court will always be retrospective in nature unless the judgment itself specifically states that the judgment will operate prospectively.
That is the principle, but see, this principle is applicable when you are claiming rights under a particular statute or a set of rules. Your right you are claiming on the basis of a judgment.
Lordships.
This judgment has laid down a parameter. So this parameter will be applicable from the day the judgment is delivered.
Lordships,
This
this
interpretation which you are trying to give is the interpretation, correct interpretation, but where your rights are identified under a statute, under a law, under some custom prevalent. In your case, you are not claiming it under any rules. It is not your case that the service rules or the FRSR rules have granted you that benefit, but it was denied. Subsequently, this was clarified in Rafiq Masi. Then yes, it will relate back. But your entire case is based on Rafiq Masi. And Rafiq Masi cannot be retrospective from a date when the judgment is delivered. It has laid down certain parameters. These parameters, you have Rafiq Masi here.
Lordships, this আছে আপনার লগত? Lordship, I have the copy, Lordship.
Yes, please carry on. It has examined the judgments, earlier precedents. And then para 18, it has laid down the parameters. And you base your claims on the basis of para 18.
Para 18, Lordships.
Yes.
It is not possible to postulate. And Lordship, this regarding delay, Lordships, that judgment also I have placed before the Honorable Court, Lordships. That is, Lordships, 2022 Supreme Court 467, Lordships. Rusi Bhai, Jagdish Bhai Pathak versus Bhavanagar Municipal Corporation. Lordships, in this Lordships, the writ petitioner has approached before the Honorable Court after 7 years, Lordships. Paragraph 7, Lordships. And he got the relief. And also, Lordships, in this judgment, this interpretation is made that Union of India and others versus Tarsem Singh, he has approached before the Honorable Court after 16 years, Lordships. And that writ petition is also allowed, Lordships. However, in after 16 years, when he approached, when the petitioner approached, Lordships, he approached along with interest, Lordships. Interest, And that interest, as there is a time bar for filing the writ petition 3 years, and accordingly, Lordship, this honorable court granted relief interest for the last 3 years, Lordships. Though he claimed for 16 years, Lordships.
So in Tarsem saying the claim was to pay arrears for 16 years with interest. That was restricted to 3 years and
3 years, Lordships. And that writ petition was allowed, Lordships.
Hello. So if you were conceding to that, you want it only for 3 years, we can consider that. You have come after
Lordships, 10 years, Lordships.
10 years.
10 years, Lordship. Lordships, this might delay, Lordships, it is well interpreted in paragraph number 6.
Yes, Mr. Kotaku, what do you say?
3-point adjournment because this case was handled by the KP Patapon. He's on leg, so I did on.
Is he not free?
He's
No?
on leg, my man.
Lordships.
Next week?
Next week, Lordship.
This also is on the request made by the council for APTCL as Mr. KP Pathak, standing counsel for APTCL is not available in court. And a request is made on his behalf, please, next week. 20, when do you want it?
Lordship, any day next week, Lordships.
26th?
Highly obliged.
I think
Yes.
Here the basic issue is regarding upgradation of the grade pay of the pharmacists. Here, the health department moved the finance department. But the proposal was turned down with an observation that they will have to move again with certain
Clarification.
They have to redo an exercise of redesignating the post of head pharmacist, senior pharmacist and pharmacist pursuant to an observation made in the ROP of 1998. That exercise, Parag, I'd like to have the instruction. If that is forwarded, then this particular 2 petitions can be disposed of. Who will forward it? Health will forward to the that updated instruction only on that point. Otherwise, the rejection is there. Finance is rejected with that particular observation.
Yes.
So on next week, or on Friday, I will have the sort of instruction from the directorate. So there is a letter from the government to the directorate to resubmit the proposal along with the necessary clarification.
You want instructions as to whether the proposal has been
Yes, if it is mooted out, the question of considering the same before this honorable court whether they will get or not. It's not necessary as on this.
My lord, only thing is that what my friend is saying, the ball is in their court now. If it is not mooted, they have to moot it, my lord.
Yes, that's why, if it is already
If it is not mooted, then they have to do it
I
again.
think that line can be disposed of on the main statement. On Friday or because one must take must. You have annexed that particular observation on that.
So what is your instruction with regard to the health department? Are they required to?
The finance is given the the particular.
No, have they?
That
Is there an option that they may not send the proposal?
No, I don't think so, because they have been putting the proposal earlier. Now, what the director has done subsequent to that observation made the finance department, that I will have the inspection.
Right, after 2 weeks on the submissions made by the Standing Council Health that the health department, the finance department rejected the proposal for
upgradation of the grade pay.
Upgradation of the grade pay on with certain observations, requesting the health department to resubmit the proposal with after incorporating those observations and
That is
observations.
primarily nomenclature of the post, I suppose. Right?
Nomenclature of the.
The counsel for the additional AG appearing for the state submits that matter can be deferred to permit him to update on his instructions as to whether the revised proposal has been forwarded by the health department in terms of the observations made by the finance department. Prayer made is not objected to by the council for the respondent list again.
My lord,
After
either
2 weeks.
9th or 11th of September. Let it be 9th, my lord.
16th. 16th September.
Deeply obliged.
Item 13.
Yes.
So that was the case, my lord, date of birth, my lord, regarding that issue inquiry was done, my lord. Both the date of birth were accepted, my lord. And subsequently, my lord, I have placed some judgment, my lord, also, my lord. In 21(5) GLT, it is fully covered case, my lord, because my lord, petitioner also, my lord, initial date of birth was my lord, 56, my lord, date was accepted, and 66 was also accepted, my lord. If two dates are there, my lord, then it has to, my lord, calculate the first in date of, my lord, birth, date, my lord, and subsequently, my lord, notional benefit has to be given, my lord. Because, my lord, so far recovery is not permissible according to law, my lord. And all everything specifically mentioned in the judgment, my lord. Jagadish Prasad Pandey, my lord.
Yes, Mr. Nayak.
Lordship is taking up this matter for disposal.
Yes.
Now, so far as facts are concerned, more or less Lordship is aware about the facts. Only 2-3 things, Lordship, I would like to point out. If Lordship first like to come to page 39 of my affidavit document.
Yes. Yes.
Lordship, this is the service book of the petitioner. Lordship, may kindly see the date of birth. This is mentioned as 31/12/1956. And it was signed by the concerned officer on 30/12/2014. And serial number 11, Lordship. Firm impression of the petitioner was also there. Lordship, this date was inserted on the basis of a certificate at page 39, Lordship. Issued by the principal Paka Higher Secondary School on 27/5/2005. Lordship, may kindly see the date of birth 31/12/1956.
What are you trying to recover? His salary, which he has.
Overstay amount.
The salary part.
That was paid during the overstay.
Salary part.
Yes, sir. So this was the certificate submitted by the petitioner himself, wherein the date of birth is mentioned as 31/12/1956. Down below, Lordship may also see the firm impression of the petitioner. Lordship, his service was regularized in the year 2005. And in my affidavit, Lordship, if Lordship comes to
Annexure 2, Lordship. Page 40. This is the regularization order, Lordship. One page is missing there, Lordship. Lordship, there, Lordship, I can see the date of birth they are mentioned as 31/12/1956. Accordingly, his date of retirement was fixed as 2016.
You are referring to which document?
This is the annexure 2, page 40.
Page 40.
This page should have been there, Lordship. Somehow this was missed.
So where is the date of birth mentioned?
That green color mark, Lord.
This one?
Yes. That is the regularization order. That was the approval of the finance department. So therein also, Lordship, this is in 2005.
Where is the date of birth?
Lordship, kindly see the entire row. Date of birth is there and date of retirement is also there. Retirement 2016, date of birth 1956.
It says 1985.
85, Lordship, date of entry into service.
But there is no other date here.
Yes, it is there, Lord. It is there. Lordship, in the first column, Lordship, date of entry is shown as 27/1985. In the second column, date of retirement is shown as 31/12/2016.
Where is the date of birth?
What is not mentioned here? The date of retirement was calculated on the basis of date of birth. And if it is taken as 1956, then you would have retired in the year 2016. That is why it is mentioned here. And if Lordship comes to then writ petition, that is it. Page 24 of the writ petition. Page 24, Annexure 6 of the writ petition. This is the statement of GPF, AIS, and PF accounts. Second row, Lordship, DOB 28/12/1956. So, Lordship, everywhere in his service record, it is mentioned as 28/12/1956. Now, in the writ petition, Lordship, petitioner annex his PAN card and Aadhaar card, Lordship. If Lordship comes to page 26, this is his Aadhaar card, Lordship. And in the second page, page 26, Lordship, if come to the lower portion, Lordship. Lordship, may kindly see the generation date, that date on which this Aadhaar card was generated, and this is mentioned as 4/12/2018.
Where do you find it?
That is the back page of the Aadhaar card, Lordship. Lordship, may kindly get a scan there. One QR code is there. It is one line is there, vertical, just generation date 4/12/2018. Towards right, Lordship.
This is at page 26.
Page 26, Annexure 8. This is his Aadhaar card. Lordship, may kindly look at the back page of the Aadhaar card, Lordship.
Yes,
And
generated.
one QR code is there.
Hmm.
Next one line is there, generation date, 4/12/2018. Got it, Lordship? So till the date of retirement, that is up to 2016.
Yes.
There was only one date of birth. He never disputed that date of birth. He never applied for correction of that date of birth. So he was never in disagreement so far as the date that was inserted in the service book, his PF account, and every service record.
What about the identity card?
That is also subsequent also. This was issued in the year 2020.
After his retirement?
After his lordship, till that time he was continuing, but it was subsequent to 2016. And Lordship may kindly see one, this may not have any relevance. Lordship may kindly see the photograph at page 26. He is claiming that this person should retire in the year 2026. He is not yet 60.
How do you make out from a photograph? That too black and white. You can make out, I can't make out.
So these are the facts, Lordship. So as he never had any dispute as regards his date of birth, so there was never an attempt made to correct his date of birth. And it was only after when he was issued a notice by a committee constituted for the purpose of his date of birth, he submitted these documents, Lordship. One that was generated in the year 2018.
See, going by from his standpoint, he was not required to, because according to him, his date of birth is 66. He is continuing.
That
was
was
earning his salary.
Lordship, date of birth, only date of birth will be regarded, will be taken into account, which is written in the service book.
I think
And
problem
that is why at the very beginning, Lordship, I pointed out to the
somebody prepared the salary bill, raised, he is earning money.
that may not be the exact position of law, Lordship.
I can understand.
That is why
I can understand this objection coming where his claim is that he should be allowed to continue in service.
Yes, he's still continuing. He is praying for continuing till 2026.
You are still continuing?
No.
Lordship,
No. After August, my lord, 2000, my lord, it has been stopped totally. Nothing has been with effect from August 2020, my lord.
Prayer to page 13. To release him arrear salary as well as current salary with effect from the month of August 2020 till his retirement in service as a regular master MR or labor till reaching his actual date of retirement, that is 27/7/2026.
Obviously, I have to write on the basis of my date of birth. Subsequently, it was accepted in.
No, but when was he released from service?
It was in the month of
July
2020.
So July 2020, you don't deduct his salary, whatever you paid, you paid.
So that is the issue, Lordship.
Page 20.
My basic submission will be, Lordship, whether petitioner was aware about the date mentioned in the service book or not. If he was aware, and in spite of that, Lordship, he did not inform the authority, but that I should not continue beyond that date, and I should have returned on that date, it amounts to misrepresentation. That is, on that point only, Lordship, I would like to place 2-3 judgments.
Where under the FR is that rule?
FR 8, Lordship. FR 8 says, at the fag end of the career, you cannot pray for correction of your date of birth.
That is there.
3 years.
3 years.
No, you had pointed out, I think, in the pension rules.
95, rule 95. 95 states, Lordship, even if it is not intimated to the petitioner or the employee,
He does not have any right to continue.
This is the procedure.
And 95 state, generally we should implement the person concerned that he is returning, but even if it is not intimated.
Yes.
So that is the law also.
Now come to the judgments.
Court judgment not fine. So Lordship, first one is 1997 7 SCC 239. (1997) 9 SCC 239.
Do you have a copy? All right, you will take it down. Yes.
1997 9 SCC 239.
What's the name of the party?
This is Radhakishan versus Union of India and others.
Paragraphs.
Not, I'm reading paragraph 1, 2, 3, and 5. Paragraph 1. This is an astonishing and more shocking case. The petitioner, who was admittedly to retire on 31/5/1991, remained in office till 31/5/1994, as if he was not to retire from service, enjoying all the benefits of service. 2. This special leave petition arises from the order of the Central Administrative Tribunal, Patna, Bihar, made on 26/11/1996, OA number 652 of 1995. The petitioner had joined the service in Telecommunications Department. Admittedly, his date of birth is 13/5/1933. On attaining age of superannuation, he was to retire on 31/5/1991. Instead, he remained in service till 31/5/1994. When action was taken to recover the amounts paid to him for the period beyond the date he was to retire, that is 31/5/1991, and to which he was not entitled, he filed OA in the tribunal and the same has been dismissed. Thus, this special leave petition. 3. The learned counsel for the petitioner contains that since the petitioner has worked during the period, he is entitled to the payment of the pay and allowances from 1/6/1991 to 26/6/1994, and that he is also entitled to the payment of provisional pension, death cum retirement gratuity, leave encashment, commutation of pension amount, GPF money, and the amount deposited under CGHS on the plea that he retired from service on 31/5/1994. We are aghast to notice the boldness with which it is claimed that he is entitled to all the benefits with effect from the above said date when admittedly he was to retire on 31/5/1991. It would be an obvious case of absolute irresponsibility on the part of the officer concerned in the establishment in the section concerned for not taking any action to have the petitioner retired from service on his attainment of attaining superannuation. It is true that the petitioner worked during that period, but when he is not to continue to be in service as per law, he has no right to claim the salary, etc. It is not the case that he was re-employed in the public interest after attaining superannuation. Under these circumstances, we do not find any illegality in the action taken by the authorities in refusing to grant the benefits. Paragraph 5. Under those circumstances, we dismiss the petition with a direction to the Government of India to take appropriate disciplinary action against all the persons concerned for their deliberate dereliction of duty in not ensuring the petitioner's retirement on his attaining the age of superannuation. So that is the first case I am referring, Lordship. Lordship, to distinguish this case, Lordship, I am referring to another judgment, that is Pandey Jagadish Prasad.
Which case you want to distinguish?
No, I am not distinguishing. In fact, Lordship, in what situation this case applies, Lordship, and in what situation this case do not apply. For that purpose, Lordship, I am referring to judgment that is 2009 3 SCC 117.
What is the name?
This is State of Bihar and others versus Pandey Jagadish Prasad.
So this is relied upon.
Paragraph 28, Lordship.
Yes.
Paragraph 28. Before parting with this order, we may refer to a decision of this court strongly relied on by the Learned Counsel for the appellant, namely Radhakishan versus Union of India. Learned Counsel for the appellant, relying on this decision, sought to argue that even if the respondents had worked after his due date of superannuation, without having any objection from the appellant was entitled to deduct the amount already received by the respondent from his retirement benefits. This case, in our view, is clearly distinguishable from the present case. In Radhakishan case, there was no dispute as to the date of retirement of the appellant in that appeal, as there was no controversy in the date of birth of the appellant. There was only one date of birth mentioned, and he had not retired on the basis of his date of birth so entered. Therefore, he had wrongly extended his service beyond the date of his superannuation, but in the present case, there were two dates of birth recorded in the service book of the respondent. Therefore, there was a clear confusion in the mind of the respondent as to whether the appellant had accepted his corrected date of birth as entered in the service book, when admittedly, the authorities concerned did not serve any notice of retirement on the basis of the initial entry of date of birth in his service book. So in the present case also, Lordship, there is only one date of birth till the date of retirement, that is up to 2016. Till the date of retirement, as was fixed by the government, Lordship, in the regularization order, there was no dispute raised by the petitioner. Never any application was made for correction of that date of birth. So in case of the present petitioner, Lordship, there was only date of birth, and these subsequent dates that he is trying to project, Lordship, is only an afterthought, Lordship, nothing else. So that is my second judgment, Lordship. Third, Lordship, I am placing one judgment, Lordship. That is 2012 8 SCC 417. 2012 8 SCC 417.
Party name.
This is Sandeep Prasad Uniyal and others versus State of Uttarakhand and others.
Paragraphs.
I'm referring to paragraph 11 and 14.
Yes.
Paragraph 11, Lordship.
Yes.
We may, in this respect, refer to the judgment of a two-judge bench of this court in Colonel B.J. Akara case, where this court, after referring to Shyam Babu Verma case, Sahib Ram case, and a few other decisions held as follows. 28. Such relief, restraining recovery, back of excess payment is granted by courts not because of any right in the employees, but in equity. In exercise of judicial discretion to relieve the employees from the hardship, that will be caused if recovery is implemented. A government servant, particularly one in the lower rank of service, would spend whatever emoluments he receives for the upkeep of his family, if he receives an excess payment for a long period, he would spend it genuinely believing that he is entitled to it. As any subsequent action to recover the excess payment will cause undue hardship to him. Relief is granted in that behalf. But where the employee had knowledge that the payment received was in excess of what was due or wrongly paid, or where the error is detected or corrected within a short time of wrong payment, courts will not grant relief against recovery. The matter being in the realm of judicial discretion, courts may, on the facts and circumstances of any particular case, refuse to grant such relief against recovery. So again, I am submitting, Lordship, it was to his knowledge that he is retiring on 2016. If Lordship comes to paragraph 14.
Sorry, para?
14.
1-4.
Yes, Lord.
Yes.
We are concerned with the excess payment of public money, which is often described as taxpayers' money, which belongs neither to the officers who have affected overpayment, nor to the recipients. We fail to see why the concept of fraud or misrepresentation is being brought in such situations. The question to be asked is whether excess money has been paid or not, maybe due to a bona fide mistake, possibly affecting excess payment of public money by the government officer, may be due to various reasons like negligence, carelessness, collusion, favoritism, etc. Because money in such situation does not belong to the payer or the payee. Situations may also arise where both the payer and the payee are at fault. Then the mistake is mutual. Payments are being effected in many situations without any authority of law, and payments have been received by the recipients also without any authority of law. Any amount paid, received without the authority of law can always be recovered, barring few exceptions of extreme hardships, but not as a matter of right. In such situations, law implies an obligation on the payee to repay the money, otherwise it would amount to unjust enrichment.
He was employed as what? Grade 4?
Yes, Lord.
Then
And
hardship.
after his retirement, Lordship, he will.
Hardship?
Hardship, Lordship, he will receive pension. Where from the hardship comes? If
No, if you deduct from you are deducting from his pension only.
not the.
How will you
That can
adjust
be
it?
adjusted. Lordship, he cannot give double benefit. If for this particular period he receives salary, at least he is not entitled to receive pension for this same period. He cannot get the double benefit, Lordship. That is what I am saying.
What is the amount?
Lordship?
What is the amount he is likely to get?
Pension. In today's calculation, Lordship, it will be more than 30,000 or 40,000.
Per month?
Yes, Lordship. So there is no question of any hardship, Lordship. a person who will get pension about, even if it is 25,000 lodging. So this is my lordship. It is not that excess paid amount cannot be recovered. It can be recovered. And lordship, this same principle was followed by our High Court also in a very recent judgment, lordship. Lordship, one judgment I furnished on the last day, lordship.
So, but you also have to address the coordinate bench judgment in his favor. How do you welcome that?
Lordship,
There's a judgment of this court in his favor, which he has relied on.
their Rafiq Masih was followed, lordship.
No. Judgment of this court.
2000
Jagdish
GLT.
Dekha.
The Jagadish Dekha says.
Ultimately, lordship will have to decide whether
But
the principle.
you have to address
Yes.
whether the
That is
judgment
why I
is
am submitting
applicable or not
lordship.
applicable.
Ultimately, lordship will have to take a call whether the judgment settled by the Supreme Court will be followed or by a High Court.
But at least there must be a submission from your end.
I have not yet gone through that.
You have to go through the judgment. It has elaborately referred to these two at least this Pandey judgment.
Yes. Now in Pandey lordship, there were two dates of birth. In this case also probably there were two dates of birth. That is why Pandey Jagadishwar Prasad was followed.
In my case also both the date accepted.
In your case, only one date
No,
of
no.
birth. Till the date of
66
retirement.
also, inquiry report it is
66
mentioned,
not.
specifically mentioned, they accepted it. Page 42 in your FUDP.
Yes.
But the next judgment lordship, I'm facing lordship, this is WA 236 of 2025.
WA.
WA 236 of 2025.
What is the name of the party?
This is Sukhomoy Dev versus State of Assam.
Yes.
Dear Lordship, if Lordship comes to no paragraphs are there, Lordship, it is at page 4. 5 pages are there. Page 4 of the judgment.
Yes.
It was noted, second paragraph.
Yes.
It was noted by the learned single judge that many a times the courts refrain themselves from passing orders for recovery of the excess amount already paid to an employee. But that is not because any right in the employee. This is only on the grounds of equity. A government servant, particularly in the lower rung of service, may spend every emolument which he receives for his family, and if such excess payment is made to him for a long time, he could genuinely believe that he is entitled to it. Precisely for this reason, the courts have held in their judicial discretion that for the employees of the lower ranks or the employees who have retired, there should not be recovery of the excess amount, but only when such excess amount is not because of fault of the employee or his collusion in getting paid more than his entitlement. Whenever an employee has the knowledge that the payment received by him is in excess of what is due to him or excess amount has wrongly been paid to him, such discretion may not be exercised. So this is the same principle, Lordship, as was laid down in the judgment of Sandeep Prasad Uniyal by the Supreme Court, Lordship. So basically, these are my grounds, Lordship. One provision I would like to place, Lordship. What is fraud, Lordship? For that, Lordship, I am referring to Section 17 of the Indian Contract Act.
Clause
Section 17, Lordship.
17.
Fraud.
Yes.
Fraud means and includes any of the following acts committed by a party to a contract or with his connivance or by his agent with intent to deceive another party thereto of his agent or to induce him to enter into a contract. I am at serial number 2, Lordship. The active concealment of a fact by one having knowledge or belief of the fact. So he was aware. And if Lordship comes to the explanation in the next page, Lordship. Explanation, mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silence to speak, or unless his silence is in itself equivalent to speech. So that is the explanation.
No, but this will not be relevant here because you did not take any proceedings against the persons concerned.
We have taken lots. We have taken the person against one person. We have already initiated DP and
with a warning.
Maybe Lordship, if Lordship is not satisfied with this, that penalty.
No, it's not a question of being satisfied.
We can.
There is a finding in the report that that other person
has
manipulated.
Along with the petitioner, manufactured the documents.
No, not manufactured. In connivance.
Exact what is
manipulated, I think.
Manipulated. Manipulated. All these records appears to be clearly manipulated by the concerned billing assistant Sri Nohendra Sharma in connivance with Sri Bolenboro among others. So that is the finding of the inquiry committee, Lordship.
All right.
So last Lordship, one judgment is there, that is Rafiq Masih, Lordship. I would like to distinguish that judgment by saying that so far as that judgment is concerned, do not apply in case of overstay, Lordship. I am at serial paragraph number 3. Paragraph number 3.
Yes.
3.
There are
issue
three.
that 3 Lordship.
Yes.
The issue that we have been required to adjudicate is whether all the private respondents against whom an order of recovery of the excess amount has been made should be exempted in law from the reimbursement of the same to the employer. For the applicability of the instant order and the conclusions recorded by us hereinafter, the ingredients depicted in the foregoing 2 paragraphs are essentially indispensable. Now, Lordship will read 1 and 2. All the private respondents in the present branch of cases were given monetary benefits which were in excess of their entitlement. These benefits flowed to them consequent upon a mistake committed by the competent authority concerned in determining the emoluments payable to them. The mistake could have occurred on account of a variety of reasons, including the grant of status, which the employee concerned was not entitled to, or payment of salary in a higher scale than in consonance of the right of the employee concerned, or because of a wrongful fixation of salary of the employee, consequent upon the upward revision of pay scale, or for having been granted allowances for which the employee concerned was not authorized. The long and short of the matter is that all the private respondents were beneficiaries of a mistake committed by the employer, and on account of the said
unintentional mistake, the employees were in receipt of monetary benefits beyond their due. 2. Another essential factual component in this bunch of cases is that the respondent employees were not guilty of furnishing any incorrect information, which has led to competent authority to concern to commit the mistake of making a higher payment to the employee. The payment of higher dues to the private respondents in all these cases was not on account of any misrepresentation made by them, nor was it on account of any fraud committed by them. Any participation of the private respondents in the mistake committed by the employer in extending the undeserved monetary benefits to the respondent employees is totally ruled out. It would therefore not be incorrect to record that the private respondents were as innocent as their employees in the wrongful determination of the inflated emoluments. Overstay portion is not there. These are all wrong calculation of allowances, wrong calculation of revision, wrong grant of status, etc., etc. Overstay is not at all there. So accordingly, I am submitting on the basis of this paragraph 3, last 3 lines, for the applicability of the instant order and the conclusions recorded by us hereinafter, the ingredients depicted in the foregoing 2 paragraphs are essentially in this figure. So if these grounds are not there, then this judgment is not applicable in case of overstay. So that is
Yes. What do you say about the other judgments? There is one more, 2 coordinate bench judgments here. Who is referred to? One by the petitioner.
2021 5 GLT.
And 23?
Yes.
Who is referred to this?
So far as this Jagadish Kumar Deka Lordship, here the principle as for the overstay service recovery of excess salary paid to the overstay period not permissible pension to be fixed and paid as per the accurate date of birth, Lordship. So that is one portion, Lordship.
So if you want to, have you gone through the judgment?
Not exactly, Lordship.
They go through the judgment. There is another one.
23. 23.
23.
Yes.
Supreme today.
Yes.
Who has relied on your petitioner?
Yes, my lord.
Right. You given the citation?
So far as this Jagadish Kumar Deka is not concerned, Lordship, definitely in this case, 2 dates of date of birth were there.
No, we are asking if you want to go through, you go through. Otherwise, we are closing it.
Lordship, I'm
You
going
go through and revert back to us day after tomorrow. The day after. Please. It has been hard as some level because we do it day after tomorrow.
Is this not on 26 or 27?
26, 27.
No, yeah,
26, 27. All right.
Right.
Twenty-six.
Having added 14.
Here, my lord, in this case, my lord, petitioner, my lord, is a third wife, my lord. First wife died, my lord. Second wife had left. Subsequently, my lord, she had filed an maintenance, my lord. That was allowed, my lord.
Who are you?
My lord, I am the legally wedded wife. What happened is that the petitioner is the illegitimate wife, my lord. They never, like, our marriage was still in subsistence. The said person had never divorced me. And then he got married.
Whose name is there in the nominee?
My lord, in fact, my lord, the petitioner, present petitioner was issued the, my lord, next of kin certificate, my lord, as well as, my lord, succession certificate also, my lord.
That was based on
On what basis, if you're the third wife, on what basis are you claiming that?
My lord,
You admit you're the third wife.
yes, I am admitting, my lord.
Ah,
I
then-
am not admitting, but I am having two minor daughters, my lord.
Maybe.
Now, my lord, we are in agreeable position, my lord, that we'll share the pension. The respondent numbers.
Who's for the state? Who's for the state? Who is the
Not a union, my lord.
Who's for the union?
My lord, Mr. UK Goswami.
Where is he?
He was earlier he was there, my lord. In the
UK
morning.
Goswami?
Now we are agreed, my lord, that pension, my lord, the daughters, my lord.
Was the pension released?
No, my lord.
What has happened is, because of this confusion, the entire scenario, our pension has been kept in a limbo. If my lord kindly has page 57 for a moment, that is the addition activity.
Yeah.
Lecture 7, my lord. Here, my lord, the authorities, they've actually laid down the demarcation, my lord. Total amount, my lord, 15,090, which is equally to be divided.
15,000?
15,950 rupees. The pension amount. And our names are there. So, my lord.
Who is Dipamoni?
My lord, Deep Moni Hira is not.
Dipmoni.
Deep Moni Hira is the son of the first wife who has passed. But my lord.
Who is expired?
Who is expired. But my lord, Deep Moni Hira is not eligible because he has
No,
married.
but if he's expired, he's expired.
No, my
No,
lord.
no, he is there. He is
Her
the-
mother expired. His mother
His
expired.
mother expired.
All right.
He is otherwise also not eligible because, my lord, he is married. And as per CCS rule 54 subclause 6 subrule 2, a married person is not eligible. Married son.
He's 25 years also.
No, my lord, that age has to be verified. There are certain annexures filed
Then
by.
who is Prabha Kumari?
I am Prabha Kumari. I am the legitimate wife.
How do you claim you're the legitimate wife in place of Dipmoni's mother?
My lord, because Deep Moni's mother passed away. Then in 2007, we got married. 34, 2007, we got married. Then, my lord, what had happened is that while we were married, the late Jukti Ram Hira, the person who has died, he fell in love with the petitioner and he went away. I also went away to my mother's house. I was getting maintenance. I had filed a maintenance case. I was getting maintenance, but we had never got a divorce between us. And he got married to the petitioner subsequently. So, my lord, the petitioner out here is not eligible. As per section 11 of the Hindu Marriage Act, the marriage between Jukti Ram Hira and the petitioner is void. However, my lord, in light of Rameshwari Devi judgment, which is a settled principle, the illegitimate children, the children of the petitioner, are entitled to the pension. With my fairness, I am submitting this. I am also eligible along with the two children.
But where is the union? CGC?
UK Goswami sir appears to.
না দেখা পাইছিল ফার্স্ট হাফে দেখা পাইছিল
All right, we'll keep it day after. Just day after, and as the learned CGC is not before the court. Copy of this order we mark to the office of ESGI. This one so and so date.
Day after tomorrow, my lord.
Day after tomorrow.
I'm deeply obliged.
I think 27.
Yes, Mr. Manu.
Yes. May it please you. This matter, your lordship, with regard to the fact that the person was terminated without following the departmental inquiry on the ground that he was let off on probation under the provision of Offenders Act. Lordship has earlier heard this matter on the ground. My case is that even if he is convicted and then let off under the provision of Offenders Act, he is entitled to the procedure of inquiry and notice and the natural justice. This is basically the case which
Provision of Offenders Act. Yes.
Lordship
Yes,
will-
please.
The impugn order is at page 91. I'll come to the provision of Offenders Act. Before that, I'll just show that page 91. Annexure 19. This is on 7 July 2020. He was a grade 4 employee also, and he was dismissed. And there was without any inquiry, Your Lordship, and they found that since he is already convicted, therefore Article 311(2) of the Constitution is not required. But that is not the correct law, Your Lordship. Without following 311, they cannot terminate this service. Now the judgment of is at pay the appellate judgment, because initially he was convicted. In the appellate judgment he was again given provision that appellate judgment starts from page 48, and that page 72 is the operative part, and it was with regard to an amount of rupees 25,000. Sorry, it was an amount of 2,74,000, but that was they have stated that he has misappropriated. Ultimately, the amount was returned back to the employer by the employee, and then in the appellate court has put him under provision. And in fact, on the last occasion, I have given some judgments. Subsequently, I got some more judgments where it is very specific that in a case where a court has even given provision to the person under the provision of his Offenders Act, then the Lordship, a person can be dismissed, can be only after considering, only after following 311 of the Constitution.
Yes.
This is basically the gist of the matter. Earlier, Your Lordship, I have already argued the matter. So the judgments that I rely, some of them I think I have already given, but
No, what is your?
My case is very specific that this termination was without following 311(2) of the Constitution. So without inquiry, without any notice or natural justice. So it was an order which was passed that since you are already convicted and since you are only given provision under the provision of Offenders Act, therefore no inquiry is required. So on that ground, that's why I've shown Your Lordship the order, impugn order. So on that ground, they terminated my service without inquiry, without anything. Admitted fact, there's no inquiry. Now, Your Lordship, whether my case is basically specifically on this point that even though I am convicted and I am ultimately allowed to go under the provision of Offenders Act, Section 12, therefore I am entitled to 311 of the Constitution. Have to be followed with natural justice and notice and all. That is the basis. And on that basis, Your Lordship, on the last occasion, 1 or 2 judgments I have given, but I have got some other judgments also. Take the DDS.
No, what are you trying to urge before the court that in view of you being released on good conduct?
Good provision.
Provision.
Provision, huh? under the Probation of Offenders Act. So what the Act,
What does section 12 say?
that is why your lordship will kindly take up section 12 of the Act. Notwithstanding anything contained in any law, a person found guilty of an offence and dealt with under the provision of section 3 or 4 shall not suffer disqualification, if any, attaching to a conviction of an offence under such. So my disqualification will not be affected in service if I am under the provision of Probation of Offenders Act, I am your lordship given probation by the court. So that is under 3 and 4. Section 3 and 4 also states that in such and such cases it can be. So that is basically the case. That's why the judgment, which also all the judgments are on the same topic. First, and old judgment, AIR 1975, Supreme Court 2216. This is with regard to the Divisional Personnel Officer, Southern Railway versus TR Chalappan. Here I'll just refer to two paragraphs, 12 and 13.
12 and 13.
12 and 13, para 12 and 13. This is with that 75 Supreme Court 2216. So here, your lordship, the court has quoted the the section 12 at para 12 itself, and then came to a finding. I'll just read that. Another point which is closely connected with the question, closely with this question, is to the effect of section 12 of the Act, which runs thus: notwithstanding anything contained in any law, a person found guilty of an offence and dealt with under the provision of section 3 or 4 shall not suffer disqualification, if any, attaching to a conviction of an offence under such law. It is suggested that the section 12 of the Act completely obliterates and the effect of any conviction and wipes out the disqualification attached to a conviction of an offence under such law. The argument, in my opinion, is based on a gross misreading of the provision of section 12 of the Act. The word attaching to a conviction of an offence under such law refer to two contingencies. There must be a disqualification resulting from a conviction, and that the disqualification must be provided by some law other than the Provision of Offenders Act. The penal code does not contain any such disqualification. Therefore, it cannot be said that section 12 of the Act contemplates an automatic disqualification attaching to a conviction and obliteration of the criminal misconduct of the accused. It is also manifest that disqualification is essentially different in its connotation from the word misconduct. Disqualification cannot be automatic consequence of misconduct unless the statute so requires. Proof of misconduct may or may not lead to disqualification, because this matter rests on the facts and circumstances of a particular case or on the language in which the particular statute is covered. In the instant case, neither Article 311, 2 Proviso A nor Rule so and so rules contain any express provision that the moment a person is found guilty of a misconduct on a criminal charge, he will have to be automatically dismissed from service. Article 311 to Proviso A is an enabling provision which merely dispenses with the various stages of departmental enquiry and show cause notice. Rule 14, despite incorporating the principle of Proviso A to Article 311(2), enjoined on the disciplinary authority to consider the circumstances of a case before passing any order. Thus, in our opinion, it is a fallacy to presume that the conviction of a delinquent employee simply citer without anything more will result in his automatic dismissal or removal from service. So, in this case, that is what I am saying. I can be removed. It's not that I cannot be terminated or disqualified, but that has to be followed by the procedure of law. Then 13, your lordship, it was, however, suggested that Rule 4 so 14 so and so is provision which contains the disqualification by dispensing with the departmental enquiries contemplated under Rule 9 to 13 of the said rule. This cannot be the position because, as we have already stated, Rule 14 only incorporates the principle of proviso of 311(2). If Section 12 of the Provision of Offenders Act completely wipe out the disqualification contained in Article 311(2) proviso, then it would become have become ultra virus, as it would have come into direct conflict with the provisions of Article 311(2). In our opinion, however, Section 12 of the Act refers only such disqualifications as are expressly mentioned in the statutes regarding holding of office or standing for elections and so on. This matter was considered by a number of high courts, and there is a consensus of judicial opinion on this point that Section 12 of the Act is not an automatic disqualification attached to the conviction itself. So here what they have stated in that order, impugn order, is that since you are already convicted, doesn't matter whether you was given provision or not, probation or not, you are automatically dismissed from service. Then another judgment your lordship will find. This is at 1997, 11 SCC 571. That is Additional DIG Police Hyderabad versus PRK Mohan.
Yes.
Here only para 4. Very short judgment. It is a settled law that Section 12 of the Provision of Offenders Act does not preclude the department from taking action for misconduct leading to the offense or his conviction thereon as per law. The section was not intended to exonerate the person from departmental punishment. It was clarified. The section only directed that the offender shall not suffer disqualification, if any, attaching to a conviction of an offense under such law. Such law in the context of other law providing for disqualification on account of conviction. This court therefore held that merely because a sentence of imprisonment has been substituted by an order passed under Section 12 of the Provision of Offenders Act, so and so, the effect of the conviction is not obliterated altogether, and it would be open to the authorities to take departmental proceedings on the basis thereof. Therefore, the observation of the appellate court on the interpretation of Section 12 is not correct. So what I am trying to point out is exactly what it says, that you can go for a departmental proceeding and thereafter you take a decision on that, whether to terminate or not. But directly it cannot be done. This, read with the earlier judgment, says what I am trying to point out here.
Where is that impugned order?
91, page 91.
No, but 311(2) gives the power to take action without holding an inquiry.
311(2) subclause A.
So that is why, your lordship, that is what I am trying to point out.
Is there anything to say that this inquiry was dispensed with?
This was dispensed with under Section 311(2)(a).
That's right.
Yes. What I am trying to point out, what the court said, that you can hold a departmental inquiry and then only you can take a decision of disqualification. Direct disqualification will not happen.
But the order doesn't say so. Order merely says under 311(2).
No, it says, but yes, it says, but is this correct? Without holding an inquiry, I can be dismissed. Or yes, this
311(2) power is there.
It has a power, but on what ground they have dismissed? Because of the conviction.
No,
Whether you can do it.
That is not apparent from the order itself. If you can say that there must be reasons to dispense with the inquiry.
Yes. Dispense.
Impugned order by itself doesn't say that it is because of that conviction. It says under we are.
No, it says it's conviction.
Conviction.
Yes. Because he was convicted by the judicial magistrate Karimganj, and the same has been appealed by him, upheld by the learned session judge Karimganj, in view of the provision of so and so, He's been dismissed without any inquiry. This is what they say. And what I am trying to point out, you cannot do that. Disqualification. It is that disqualification they are trying to point out, that you are disqualified. In a case where a person is convicted, normally a person, when he is convicted on the same offense, a departmental inquiry is not required. Because if it is the misappropriation and the same offense here, but question here is that he was convicted but given probation. When probation comes, section 12 comes. When section 12 comes, the court says that you have to have a department. But it is the case. And then other judgments are also there, where is very, in that case also.
But does it interpret 311 2C, 2A?
No, it did not interpret. It says that there has to be a departmental inquiry.
Yes, there has to be a departmental inquiry.
But whether you have the right to dispense with the departmental inquiry just because I am convicted, is that correct or not? That is the question.
Is there any reference to 311 in any of the judgments?
Just a moment. Yeah, this other judgment, your lordship, that is, I think, 1989 Supreme Court 662. There's another judgment that I have given. And oh, sorry, this is the one. 1985 to SCC 358. This is Sankar Das versus Union of India. I think
Yes.
Here, paragraph 7. It is to be lamented that despite these observations of the learned magistrate, the government chose to dismiss the appellant in a huff without applying its mind to penalty which could appropriately be imposed.
Must tell us in a nutshell the facts involved. Otherwise, how the, why the, to what effect is the conclusion will be dependent on the facts of the case, each case.
Yes.
Anyway, para 7.
One thing I would like to pray at this stage, maybe I have started the argument. Can it be some other day? I'll place a concise judgment of concise part of all these judgments. That will be easier in that case. Because even I have to read each and every judgment. That will be easier than for your lordship, inclusive of me. And at about 4 o'clock, even then, sometimes the mood is not there to be so elaborate in a case. No, it's my point. I'm not talking about your lordship. Lordship is fresh altogether. I am not.
No, that we can already feel. Therefore, we wanted you to explain to us. We restrained ourselves from asking you whether you are in a hurry.
No, I was actually apprehensive whether your lordship will allow or not. Anyways, your lordship, any other day.
The request of the counsel for the petitioner, matter stands deferred to be listed again after 2 weeks.
Yeah, the week thereafter. That means first week of September. That means maybe on any hearing day, second or fourth.
Fourth.
Lordship.
Mr. J.K. Goswami for the respondents.
Obliged.
Cited.
Supplementary for admission item 33.
Dear Lordship, my lord, this is a regularization of service, my lord. Petitioner seeking, my lord, similar relief, my lord, page 40, my lord. Order, my lord, and annexure 7. Page 40, my lord, 40. Operating part is, my lord,
No, tell us something about the effects. You want a similar relief. You might as well get a draft of the order period before us. We'll sign it for you. You must tell us what is this matter about.
My lord, My lord, petitioner was engaged as a work charge khallasi, my lord, but my lord, he was now retired, my lord.
Before which department?
Executive engineer, my lord, PhD.
What was the direction given? Who's for the respondent? Which department?
PhD, my lord.
PHE. Who appears for PHE?
R. Gawai, my lord, I will.
Let it be tomorrow.
My lord.
Matter be listed tomorrow as the counsel for the public health is not available before court. List tomorrow, showing the names of all counsels, including the respondent counsels. Counsel,
Obligatory.
yes. To order, Marie, will go to you.
It is for hearing, I think 30.
Yes.
May it please your lordship. My lord petitioner, who was working as a constable in Assam Police, challenging the order of removal from service on the ground, your lordship, number one, my lord, non-compliance of my lord provision of Article 311.
Who's for respondents?
Man, it's a government advocate, government of Assam, G Assam.
Yes.
G. Second, your lordship, it is when my lord criminal proceeding and departmental proceedings are based on same facts, same witness. In that case, my lord, departmental proceedings are not required to be continued, your lordship. And there are decision of this honorable court, my lord.
There was a departmental proceeding.
My lord. And criminal proceeding against me, my lord, that I will place, my lord, where the witnesses, evidences are same, your lordship. Allegations are same, your lordship. And I was criminal proceeding is still, my lord, pending, my lord. I was removed from service in departmental proceeding, your lordship. So, my lord, in Katina of decision
Appeal?
that, my lord,
You filed appeals.
appeal was dismissed, my lord. After what happened, what has happened, your lordship? We filed appeal, but no decision was taken in appeal. So we approached this honorable court. After approaching this honorable court, they pass an order in appeal. So we challenge that order in appeal by way of, my lord, in our reply, your lordship. That can be, my lord, that I will place, my lord. So the challenge is, my lord, removal from service, as well as, my lord, the order passed in appeal, your lordship. Mainly on the ground that before imposition of major penalty of removal from service, my lord, no opportunity of being heard given to the petitioner. This is violation of, my lord, sub article 2.
Inquiry was not held.
Inquiry was held, but after inquiry, my lord, I should have been given an opportunity to answer why I should not be, my lord, removed from service.
You have been heard in the inquiry. Why further?
Well, but Article 311 says, my lord, before imposition of penalty, my lord.
So inquiry report was submitted to
Submitted, my lord.
you represented before the authorities?
My lord, but in the inquiry report, my lord, there is no so cause notice whether they are going to impose, my lord, major penalty of removal from service or not.
Where is the show cause?
So cause, my lord, your lordship may kindly come to
41.
page 41. So cause women constable so and so 26/8/2021, my lord. You are hereby required to so cause under section so and so, read with section so and article 311 of the Constitution of India and rule so and so as to why.
So this is your show cause.
So cause, your lordship.
You replied.
I replied, my so cause before initiation of departmental proceeding, your lordship.
Then
Then I replied, then they proceeded in
Then
the
inquiry and presenting officer appointed.
my lord, everything was appointed. We are not disputing that. I was placed under suspension also. Thereafter, I was reinstated. Thereafter, inquiry report was submitted that your lordship will find at page 53.
What was the finding?
Finding that my lord will see at page 58, my lord. During inquiry of DP number so, it was ascertained that charged officer so-and-so was arrested on so-and-so in connection with Bharlumuk PS case number so-and-so at section so-and-so of Prevention Concern Act while she was posted as DSB Difu Karbi Anglong. She was sent to judicial custody and later on granted bail along with the other co-accused. During inquiry of the proceeding, I have gone through all the relevant documents and statements of PWs, and I have also recorded statements of additional PWs. Inspector so-and-so, many PWs have denied knowing women constable Saraswati Hansu before her arrest in the said case. The case in reference is Bharlumuk PS case number so-and-so related to gold smuggling, and one SI of police, Badri Prasad Baravati, was one of the accused of that case. During investigation of Bharlumuk PS case number so-and-so, it has come to light that Badri Prasad Baravati used to transact illegally money through the account of so-and-so, which was confirmed by SCP Azra Nandini Kakati in her statement and further corroborated by the bank statement of so-and-so. There were several cash deposits in her account from 2018 to 2021 and from various mobile numbers through ATM cash deposit machines. Those numbers were further verified during recording of statement, and owners confirmed that they had used those numbers for depositing money in the account of so-and-so as given by Mr. So-and-so. PW so-and-so Manoj Das and had confirmed that they had deposited cash through ATM cash deposit machine using their mobile numbers in the account of so-and-so as directed by Mr. So-and-so. Even himself had deposited cash on various dates through his mobile number so-and-so in the account of so-and-so. Bank account statement of Srimati so-and-so Exhibit 1 was also examined during inquiry, and it was quite evident that the statements of that the several deposits in cash and through net banking had taken place in her account from 2018 to 2021 as stated by PWs. From the above records and statements of witnesses, it is evident that Sase Hansu and Sri so had maintained a cordial relation with while working together at Karbi Anglong, and because of that, Sri Badri Prasad had used the account of so-and-so for illegal transactions, and she too was benefited by the same. Although she was not directly involved into any illegal transactions, but she had never objected to such illegal proceeds also. Therefore, it may be concluded that the allegations leveled against the charge of her is proved. And the main accused, my lord, he approached this honorable court, and still, my lord, departmental proceeding has been stayed because criminal proceeding is based on departmental proceeding is based on a criminal proceeding. And my lord, I have prepared one compilation of, if your lordship desire, my lord.
No, what is your ground of challenge?
My ground of challenge is, my lord, when departmental proceeding was based on criminal proceeding, your lordship.
How?
Because the matter relating to Bharlumuk PS case number and all the PWs who adduced evidences in departmental proceeding are also PWs, my lord, in my lord, criminal proceeding.
Did you approach the court to keep the proceeding?
My lord, that we have not approached. It is true, your lordship. Other co-accused approached this honorable court, and this honorable court has stayed. But this division bench of this honorable court on that score is itself, my lord, in that case also it was removed from service. during the pendency of criminal proceeding, the division single judge has set aside that my lord removal from service. That was challenged before division bench, Itanagar bench, your lordship, and division bench has upheld the finding of learned single judge, your lordship. And number two, your lordship, before imposition of penalty of removal from service, my lord, I have not been given an opportunity to reply why I should not be removed from service. This is violation of my lord proviso to
under what provision?
Proviso to my lord Article 311, your lordship.
The whole process of the inquiry is 311.
My lord, but in proviso, it is specifically mentioned that before imposition of penalty, my lord, opportunity of being heard should be given against whom penalty is going to be imposed, my lord.
You have already
My lord, but the apex court says, my lord, at the time of imposition of penalty, at the time of imposition.
This is as per the rules,
My lord.
discipline and appeal rules. There is no specific provision.
True. But considering that aspect of Article 311, my lord, apex court in a decision that I will
the provisions of rules.
My lord, I will place, my lord. Apex court says, my lord, if the penalty has been imposed without giving the opportunity of being heard, that penalty is, my lord, none in the eye of law. My lord, it was set aside. My lord, I am placing your lordship. I have prepared compilation of 4 or 5 decisions.
No, the compilation will go, but first tell us whether.
My lord, in the compilation, it is there, your lordship. Page 63, my lord, may kindly come. 63 of the compilation first. It starts from 63 and relevant paragraph 67, paragraph 13.
Wait 1 minute. 311, you are referring to which proviso?
Proviso of 311.
Yes, please.
Article sub 2, my lord, provided that where it is proposed that such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on penalty proposed, provided further that this clause shall not apply where a person is dismissed or removed or reduced on the ground of conduct which has led to his conviction on criminal charge, where the authority empowered to dismiss or remove person or to reduce him in rank is satisfied that for some person to be recorded by the authority in writing, it is not reasonably practicable to hold such inquiry, where the president or governor, as the case may be, is satisfied that in the interest of security, my lord, I am not on that. If in respect of any such person aforesaid, the question arises whether the reasonably practicable to hold such inquiry as referred to in clause 2, the decision thereon of the authority empowered to dismiss or remove such person or to reduce him in the rank shall be final. My lord, interpreting this provision, my lord, para 13, your lordship will see page 67. Of compilation, my lord.
Yes.
On conceptus of all these decisions mentioned herein above, the irresistible conclusion follows that the impending order of discharge through caused in innocuous terms is merely a camouflage for an order of dismissal from service on the ground of misconduct. This order has been made without serving the appellant any charge sheet, without asking for any explanation from her, and without giving any opportunity so cause against the purported order of dismissal from service.
You read the facts of the case.
My lord. Start from 63, my lord. The main argument advanced on behalf of the appellant is that impugned order of discharge from service was made not in accordance with rule so-and-so of Punjab police rules, in accordance with the terms and conditions of service, but it is made by way of punishment. an inquiry was made by Deputy Police Superintendent so-and-so as the character of the appellant into the allegation that she stayed at so-and-so one or two nights with one so-and-so, and evidences were recorded therein without giving the appellant any opportunity of hearing in the inquiry and without
No,
giving,
you are skipping para 3.
my lord.
Read para 3.
This order was made. It has been stated in the petition without serving any charge sheet or on her and without asking her to explain any charge. The order also has not recorded any reason for her discharge from service. Against this order, the appellant made a
So
representation.
she was removed without any inquiry.
In that case, but here what apex court is holding, my lord, that in addition to charge sheet and all, without asking for why you should not be removed from service. Para 13, my lord, can you see? Without giving any opportunity to show cause against purported
Right,
order of dismissal.
You read para 13.
My lord.
That this order has been made without serving any charge sheet.
Charge sheet as well as, my lord, and without giving any opportunity to show cause against the purported order of dismissal from service.
Mr. Goyal.
My lord.
Once the law is that you are to be given an opportunity.
My lord.
You must know what the charges are.
My lord.
You must be given an opportunity to respond.
My lord.
The authority is not satisfied, they will appoint inquiry officer and so and so so.
My lord.
And thereafter, proceedings will start.
My lord.
Everything has been done here.
Here it has been done, but second.
But before dismissal, you have to show from the rules whether such a provision is provided, is prescribed.
Prescribed or not.
Subject to correction, it is not there in the discipline and appeal rules.
I have to also examine it. Right. Regarding, my lord, that both when the criminal proceeding is based.
But that is no longer here. You came late.
I came late, but in the division, in the Itanagar bench, same question was there. She was removed from service. And on that ground itself, my lord.
Where is that?
My lord, Kundu, that judgment. Comic Kundu, page 29, first, my lord, can you see? Single judge judgment, then division. And your lordship may kindly. Para 9. These are the facts, my lord. There also.
Para 6, she was served with a memo of charge.
Here also, my lord. Petitioner was served with memorandum of charge, article so and so. The petitioner, while being attached with the office of so and so. Para 20, page 39. Or 21, 20 and 21, my lord.
You read para 9.
Para 9. Thereafter, by order dated so-and-so, Sri so-and-so, Deputy SP, Police Headquarters, Itanagar was appointed as inquiry of authority to inquire into the charges framed against the petitioner. After the inquiry was conducted, petitioner was asked to submit her defense statement against inquiry report submitted by inquiry officer, which was forwarded to her by office memorandum. The petitioner on so-and-so submitted her written statement of defense. However, the respondent authorities concerned not being satisfied with the written statement of defense issued so cause notice dated so-and-so to the petitioner so cause as to why she should not be dismissed from service, my lord. In view of the charge made against her having been proved, the petitioner then submitted her reply to so cause notice. However, the disciplinary authority not being satisfied with the so cause notice dismissed her from service with immediate effect by order dated so and so. Ultimately, this dismissal was set aside by this honorable court, my lord. Para 20 and 21, observing that both the investigation and.
What is the stage of the criminal proceedings?
My lord, charge sheet has been filed, my lord.
Not framed.
Not framed, my lord, against me. And against this, my lord, this judgment, my lord, appeal was preferred.
What was the finding of the single judge here?
Single judge ultimately page 40, para 24. On the basis of, my lord, judgment given in M. Paul and Anthony and others, my lord. Thus, upon due consideration of the matter in its entirety, I am of the considered view that the present case falls under the exception carved out by apex court in captain that I have placed, my lord. Captain P.M. Paul Anthony. Having come to the such finding, it will not be necessary to dwell upon the other authorities relied upon by the London Council for the rival parties. In the result, I find merit in the writ petition and the impugned order dated so and so are hereby set aside. The respondents are directed to reinstate the petition back into service. However, considering the nature of the allegations and also the role of responsibility of the petitioner as cashier of the establishment concerned, the petitioner shall not be entitled for any back wages. Against that, my lord, appeal was preferred, page 42, and division bench upheld the order passed by London single judgment. Page 61, para 36.
Then where is that appeal?
Appeal page 42 starts from 42 and relevant page 61. Findings, my lord.
What is the, where is that Paul Anthony?
Paul Anthony, my lord, that your lordship will see at page 6. Para 34, 35, and 36. Page 22.
Here the case is slightly different.
Here it was proceeding was on, but here it was concluded. But while taking into consideration only Paul Anthony, your lordship, London single judge has set aside that removal from service, and division bench upheld that. And Rajkumar Agrawal and other case also, Koseswar Dubey, page 1. It was at that inquiry was not concluded in all the cases. But our High Court, my lord, in the case where the inquiry was concluded, has been pleased to set aside that conviction, that removal from service, your lordship.
The facts are different.
Supreme Court decision,
No, in this judgment that you're referring, coordinate bench.
coordinate bench.
Here the investigation ended in a final report. Criminal investigation.
My lord.
In your case, it has ended in a charge sheet.
Charge sheet and matter is still, my lord, charge sheet, maybe final report, my lord, maybe charge sheet. Ultimately, unless and until they, the
No,
person.
where is that law?
Law is this, my lord, when the departmental proceeding is.
You read properly the judgments.
My
They operate on two different fields. There is no such thing that because criminal proceeding is there,
lord.
you'll have to wait endlessly for departmental proceeding. It is not that. Yes, where the charges are entirely identical.
Here also, my lord,
Authorities at its
Bharlumuk police station case, they are basing on the police station case and the evidences, informant, everyone is, they are also.
here in this matter which you are referring,
My lord.
the criminal investigations concluded in favor of the petitioner. In spite of that, the proceedings went and there was a dismissal.
Dismissal.
So therefore, the court interfered when it found that it is on identical case, identical facts.
We will examine, my lord. Not today, my lord.
Then why have you not examined and
My lord, I have tried to the limited my capacity, my lord. Something is coming.
You come out with the law that
My lord.
in the event, Paul Anthony was a case where the proceedings went ex parte. So there are cases, yes, where where the charges are entirely identical and they're proceeding simultaneously, then it may be advisable to keep the departmental proceedings pending.
Stay.
You did not come before the court.
My lord, we are late.
There was nothing there to restrain the proceedings. They went ahead.
In fact, my lord, the main accused, he approached this honorable court and this honorable court has stayed departmental proceeding. That is the, my lord, I will examine deeper, your lord.
List. After 1 week?
1 week, my lord. Your lordship has heard at length. My lord.
You come back and argue the matter.
My lord.
After 1 week.
My lord.
You want it next week?
Next week, my lord.
Next week. Mr. Gordon. The request made by Mr.
Date may be fixed, my lord.
And Mr. J.K. Goswami for the respondents. You pick any date you want.
26, my lord.
26, all right.
Deep, your lord.
Sir, my lord, my senior counsel is busy engaged in court number 10.
This is not a ground for adjournment, normally.
Can we pass over for the day?
All right, passed over on the request made by the council. Petitioner, Mr. M. Sharma appears for the respondents. Yes.
Lordship, in this matter, though Lordship has granted me time, Lordship, due to my personal inability, Lordship, I could not file the.
We are sorry for your personal losses. How much time would you require?
Lordship, within 10 days, I'll be able to file Lordship.
Like 2 weeks? 2 weeks.
Lordship, may kindly fix a date.
Request is made by MSM Bhattacharya that because of personal reasons, the affidavit could not be filed. And therefore, she prays for further 2 weeks.
Lordship, may kindly
Time.
fix a date.
Prayer is not disputed, a prayer objected to by the counsel for the petitioner, who however submits the matter be listed on a fixed date. 11th?
Lordship.
11 September?
Deeply obliged.
No?